May I please know? My lord, the item 60, several times it has been listed but could not reach.
Which one?
Item 60, before my lord, the last. Please. It could not be reached so many times.
60
The accredited jail custody 14 years maybe.
This way we may take it though. This way it will take off.
Pattern to maintenance, my lord. The petitioner challenges the order state administrative. Petitioner challenges the order passed by the state administrative tribunal.
We mentioned tomorrow. This is a special bench. Mention tomorrow.
Beg your pardon, Doctor. Three mentions for criminal appeals where the
Please mention tomorrow.
Supplemental list, item number 1.
My lord, on behalf of N. Panda, my lord, this is the non-compliance of order dated 12/8/2024.
Complied with. Speaking order passed on 27/2025.
The Land Council for the state has produced a compliance report. Which shows that in pursuance of this court's order, the dated 12/8, dated 12/8/2024, the representation has been disposed of by the Tahsildar Mandari Pokhari on 27/8/2024. He files the which is taken on record according to conform petition. Copy the petition with the. Yes, next.
Item 2.
Item 2, may I please, your lordship? May I please, your lordship?
Yes.
Your lordship, I am alleging the non-compliance of the order dated 5/9/2024, your lordship. In page 13 is the operative part, your lordship, wherein a direction was given to the opposite party.
Compensation.
Yes, your lordship.
Hard copy is there, so have you produced it?
Yes, your lordship. I have communicated it, and
No,
that I have annexed in Annexure 2 series.
Averment in your petition that when you communicated the order.
Your lordship, page 14 is the, I have annexed the copy as well as the postal receipt, your lordship.
So who is to obtain instruction? NHI ର କିଏ ଅଛନ୍ତି council? ସେତେବେଳେ କିଏ appeal କରୁଥିଲେ? Order ଟା ଯେତେବେଳେ pass ହେଲା A. Rautrai, SPC for Union of India. Mr. Mahanti, can you tell that who usually appears for
Mr. Amitabh Das is usually
you can at least obtain instruction. So why again will we issue notice on this matter? So that just tell Madam about the Learning Council's name so that he can serve a copy and he will take instruction. We are just leaving that portion blank. Hello? And let on do. The Learning Council for the this content petition has been filed for non-compliance of the order dated 5/9/2024 passed by this court in WPC number so. The operative is as follows. Here are the paragraph number, page number 13 in view of this so. Land Council for the petitioner submits that so council now used to appear for NHI offenses. ଆପଣ କିନ୍ତୁ କହିବେ ଆମେ ଲେଖିଦେବୁ ଯେ petitioner କହିଲେ let a copy of the content petition be served on Swans of Council to obtain instruction about the compliance of the order. Put up this matter, put a date, the name of the be reflected in the clause list. So, ma'am, you get the name from the Land and Council for the state, Mr. Mahanti, and give a copy of your content petition with the annexures so that he will obtain instruction. Okay?
Your
And
Lordship, as your Lordship
after-
pleases.
we are listing it after 2 weeks.
Obliged, your Lordship.
Item 3.
We have sent it to the concerned authority, but the request on timely development because they already communicated with 29/7/2025. If there is some time to
Kebe Patel and
on 29/7.
On the very days, on the very day the order was
Yes,
passed.
yes.
Achha, the Land and Council for the state submits that
Over telephone, I have also intimated to.
on 29/7/2025 itself. He has sought for instruction regarding the status of representation. That the instruction is awaited and the matter will be taken up after 2 weeks. After 2 weeks. So, roughly on the 8th April, on 8th April, 2 April, is this matter on 2025. These are your option either Mongolwar knowledge Guruvar. ठीक है. So these are the two in order of them. Yeah.
Item 4.
I am for the opposition bank. Lordship had ordered 29/7/2025. Directed the register DRT to produce the record. Because in the report of retribution,
From the
Yes, yes.
from the records on the transfer that also highly was kept for hours and hearing the same. And for this side after requested one of the asset, the matter was all in part. For a dimension, submit 18 months of information posted from purpose. We know from time to time the matter of system and final and seven is listed between 13/3/2025 tomorrow. So tomorrow, so let it come, then on 2nd, and he will submit up to date report. And Asunda Kali achieve. Yes. Left on the peruse the, no, as per the order dated, such and such, the land and register, on DRT has submitted the report dated 11/1/2025. Wherein it is stated as follows, it is from the record to let's see the 13/8/2025 for number of the order. This matter on 2nd September 2025. The land registered DRT shall submit a further report relating to the status of swans. Yes. So do it and
Item 5.
also report.
Report of sample.
after note 2 and 3 concerned, we are sending the letter on 4/8/2025. To the superintendent jail Keonjhar and the another so for family concerned, they are staying at the Biju Bandai open, but they are not giving any report.
Appellant ଆମେ ଦି ଜଣ ଆପେଲାଣ୍ଟ ପାଇଁ
ହଁ।
କହିଥିଲୁ
We have
ଜମାଦାର ଓରଫ ଜୟପ୍ରକାଶ ଲଗୁରି ଆଉ
And,
ନାନୁ
Naresh.
ଆଲିଆସ ନରେଶ ତା ନାଁ
Langu-
କଣ ଜଣ୍ଡା
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 Languri.
ଏଇଟା ଆପଣ କାହାର ଏଇଟା କଣ ବିଜୟ ଆଣିଲେନି ବିଜୟ ସ୍ୱାଇଁ
ଏଇ case ରେ ବି ନୁହଁ,
ଏଟା କେବେ
ଏଟା ତ ବିଜୟ ବୋଲତେ ଏଠି।
241 କି ବିଜୟ ନାୟକ ଅଛନ୍ତି କି ମିଷ୍ଟର
No, no. Difficult, my lord. I have also some document.
He says that he has not received the report.
No, no, that
No,
report
no,
is there, but this is
but
not a
he-
man of this
ଏଇ
case.
appeal 241 କନେକ୍ସନ ରେ ଯେହେତୁ ଏଇଟା
ବିଜୟ କେହି
ଆସିଛି
ନାହିଁ।
ଆଜି ତ ବିଜୟ କେହି ନାହାନ୍ତି ଟୋଟାଲ ଆପେଲାଣ୍ଟ ହଉଛନ୍ତି 6
ଛଅ
ଜଣ
ଜଣ।
6 ଜଣରୁ ଯିଏ ମରିଗଲାଣି ବାକି ଯୋଉମାନେ ବି ଅଛନ୍ତି କି ଇନିସିଆଲ ଷ୍ଟେଜରେ ବିଜୟ କେହି
ନାହିଁ,
ନଥିଲେ
business,
ସନ୍ ଅଫ ମାଗାତି ନାୟକ ସେମିତି କେହି
କେହି କେହି ନାହିଁ, କେହି ନାହିଁ। This is not a case at all.
ଏଇଟା କଣ ଗୋଟେ ଭୁଲ
ଏଟା କାହା case ରେ ଗୋଟେ ସେ ଦେଇ ଦେଇଛନ୍ତି।
ବାକି ଏ ବିଷୟରେ ଆପଣ ଯୋଉ କହୁଛନ୍ତି କମ୍ୟୁନିକେସନ କରିଛନ୍ତି ବୋଲି
My lord, that is the 4/8/2025 commission ଅଛି।
ୱେଲବିଂ ଅଫ କାହ୍ନୁଚରଣ ନାୟକ ଠିକ
ନାଇଁ ନାଇଁ, ତାପରେ ଏଇଟା କବି ସୂର୍ଯ୍ୟନଗର କଣ ଆସିଛି, ଏଟା କେମିତି ଆସିବ?
ନାଇଁ ଇଏ ପୁଣି ଆଉ ଗୋଟେ ଦେଖୁନାହାନ୍ତି ରିଗାର୍ଡିଂ ୱେଲବିଂ ଅଫ ଆପେଲାଣ୍ଟ କାହ୍ନୁଚରଣ
ନା
ନାୟକ
ମାନେ ଏଇଟା ପୁରା case ତ ନୁହଁ।
କେମିତି ଆଧାର ନମ୍ବର ଦେଇ ଦଉଛନ୍ତି 241
ସେ difficult, I have also print out from the ଆମର ୱେବସାଇଟ ରୁ ସେ ଅନ୍ୟ 241 ରେ ଅନ୍ୟ ଗୁଡାକ ବହୁତ ଆସୁଛି ଯୋଉଟା ମୁଁ ସ୍କ୍ରୁଟିନ
ନାଇଁ ନାଇଁ,
କରିବାକୁ
ଏଇଟା ସେ CRA 241 ରେ ଦେଇଛି, ଆୱାର ସେ CRA
CRLA
241.
241
CRLA, CRA confused ହେଇଯାଉଛନ୍ତି.
No, no, altogether different nomenclature ଟା ଅଲଗା।
ସିଆରେ ଅଛି
ଏଇଠି ଆମର ଅଛି କିନ୍ତୁ CRA
2001 ପୂର୍ବରୁ ସବୁଗୁଡା CRA ଥିଲା.
1998
ମାନେ CRA ଥିଲା
2001 ପୂର୍ବରୁ ସବୁ CRA.
ପରେ ବୋଧେ।
ନାଇଁ 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 2001 ପୂର୍ବରୁ CRA.
ତାପରେ
2003 ପୂର୍ବରୁ 4 ପରଠୁ CRA.
But Mr. Nayak, these are not the cases, the names of the person. So this is not the
not
correct,
even the police station.
so the police station ଗୁଡା
police station ତ ଆମର ଏଟା କେଉଁଝର,
ଅଲଗା
ସୂର୍ଯ୍ୟନଗର
ଏଟା କବି
ଚମ୍ପୁଆ
ସୂର୍ଯ୍ୟ
ଚମ୍ପୁଆ.
ଚମ୍ପୁଆ।
କେଉଁଝର ଡିଷ୍ଟ୍ରିକ୍ଟ ରେ, ଏଟା କବି ସୂର୍ଯ୍ୟନଗର ଗଞ୍ଜାମ।
ଇଏ ନୁହଁ ଇଏ ରିପୋର୍ଟ ନୁହେଁ ଇଏ ଅନ୍ୟ କୌଣସି ଆପଣ ଯୋଉ ଲେଖିଛନ୍ତି କୋଉଠି ଲେଖିଛନ୍ତି ତାର ଚିଠି ପୁରା ସେ ଅର୍ଡରଟା ଏତେ କ୍ଲିୟର କଲୁ ଆଉ ଯୋଉ 31
ଏକଦମ elaborative ହେଲା।
elaborative କରୁଛନ୍ତି କୋଉଠି ସେମାନେ ରହୁଛନ୍ତି ଲାଷ୍ଟ ବି ସେଟା ଲେଖା ହେଇଥିଲା
କାହିଁକି ଆମେ ମାଗୁଛୁ ସେଟା ବି ଦିଆ ହେଲା।
ଲେଖିଥିଲେ ଓକିଲାତନାମା ସାଇନ୍ ବି ହେଇଛି 19 ତାରିଖରେ ବୋଲି.
ସ୍ପେସିଫାଇ କରିକି ସେ ଦି ଜଣଙ୍କ ପାଇଁ ମୁଁ ଦିଏ ପଠେ।
କେଉଁଝର ଲେଖିଛନ୍ତି ବିଜୁ ପଟ୍ଟନାୟକ
ହଁ ମାନେ ଜାମୁଝରି ଲେଖା ହେଇଛି,
କେଉଁଝର ଦିଆଯାଇଛି ଜାମୁଝର ଦିଆଯାଇଛି ଦି ଜାଗା।
ଜମାଦାର ଆବିଟ ଲାଗୁରି ନା।
why don't you talk or you want just talk to the concerned from jail or year on. Why in every matter we will ask him to join and we'll ask, they will say that please give us time, we'll verify. This should be done from your instance. This much of information because the wakalatnama has been signed from that particular jail. And you are getting the information that one has been shifted to Biju Patnaik open jail. So it's a matter of record. So Biju Patnaik open jail ru asiba katha information. ସିଏ ବି ଦେବେ ଆଉ ଗୋଟେ ହଉଛି ସେ ଯୋଉ ଆର ଜେଲ କେଉଁଝର ଜେଲ ଏତିକି ତ କଥା. What time you want? This much of information and you are taking record ଟା verify କରି ସେ ଆମେ ତାଙ୍କୁ ବେଲ ଦେଇନୁ.
କେଉଁଝର ଜେଲକୁ ମୁଁ ଆଜି କଣ୍ଟାକ୍ଟ କରିଥିଲି ସେ କହିଲେ ଆଜ୍ଞା ସେ ଯୋଉଟା ଲେଖି ଦେଇଛନ୍ତି ତା ପୂର୍ବ ରିପୋର୍ଟଟା ନଟ୍ ଆଭେଲେବୁଲ ବୋଲି ସେ କହିଲେ ଆମେ ସେ ପେଜଟା ପାଉନୁ.
ଦି ଜଣ ଆପେଲାଣ୍ଟ କୁ 2 ଆଉ 3 କୁ ହାଇକୋର୍ଟରୁ ବେଲ ଦିଆ ହେଇନି. ବର୍ତ୍ତମାନ କିନ୍ତୁ ସେମାନେ ଗାଁରେ ଅଛନ୍ତି. ଗାଁକୁ ଗଲେ କେମିତି ଓନ୍ଲି ଅଲ୍ଟରନେଟ୍ ୱେ ଆଉଟ୍ ଆଇଦର ପ୍ୟାରୋଲେଜ ହେଇଥିବେ ନଚେତ୍ ପ୍ରି ମ୍ୟାଚୁର ରିଲିଜ ହେଇଥିବ. ସେଇତିକି ଜିନିଷ ଆମେ ଜାଣିବାକୁ ଚାହୁଁଛୁ ଯେ ଆମେ ତ ବେଲ ଛାଡିମୁ ଗାଁରେ ଯାଇ କେମିତି ରହିଛନ୍ତି. ଆପଣଙ୍କ ରିପୋର୍ଟ ଦେଖଉଛି ନା ଗାଁରେ ଅଛନ୍ତି. ତ ଯଦି ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ହେଇଥିବ why unnecessarily exercise all these things.
ଜଣେ ଆଜ୍ଞା ବେଲ ଯାଇଥିଲା ଯେମିତି ହେଲେ ଶୁଣିବାକୁ ପଡିବ.
Hmm?
One has been released on
So
bail.
far as these two, we are concerned with these two. 2 and 3, no bail order has been passed. Okay. Now they are in their village. How they have now are residing in their village?
ମୁଁ ତ କଣ୍ଟାକ୍ଟ କରିକି ମାନେ ଲୋକାଲ ସବୁ ଏରିଆ କଣ ସେ
We know that they are not responding. What do you want? You want it day after tomorrow? Look. Mr. Nayak, one additional government advocate, produces the letter dated 4/8/2025 issued the Superintendent District Jail Keonjhar, Superintendent Biju Patnaik Open Air Ashram, Chandaka Jamujhari, East Khorda, and Inspector in Charge, Champua Police Station District Keonjhar, for obtaining instruction as per the order dated 31/7/2025. He submits that he has not yet received any instruction and the matter may be taken up after tomorrow. Put up this matter on 14th of August.
not on there. I will be absent for till 20.
No, let it come, because if we give a long date,
Yes.
then they will.
No,
It's all right.
Day after tomorrow, I will be absent for till 26.
No, it's all right. Let it come like that.
Item 6.
Yes.
It's also despite of repeated reminders since 2020 about the status of the present appellant and the last letter on 1/8/2025. And I have also personally talked with the DCP and the FOL, but
Here only sole appellant.
sole appellant.
He has not been released on bail.
Yes,
Yes,
He has been released. Whether he is alive or well-being, well-being is quite right. पण ତାଙ୍କ ବନ୍ଧୁ ବାନ୍ଧବ ସମ୍ପର୍କୀୟ କେହି କହିପାରୁନାହାନ୍ତି।
ସେ difficulty face କଲେ ଆମେ ତାଙ୍କୁ ମାନେ judgment ର cost title ଆଉ trial court ର judgment ର cost title both the address were provided but still then they are unable to trace because ସେ ଜଗତପୁର ଖୋଜୁଛନ୍ତି
But think this way. Suppose he has in the meantime died. Why unnecessarily?
yes that's I talked with the DCP also
And Mr. Panda has also no instruction. The client is not responding to him. So that is the
so
reason.
may allow some time I will also today also
Mr. Panda, any response you have?
No.
When you will
Before
next
the
week how
that the COVID may not see had come one.
Oh, there as well. And we are also apprehensive of COVID only.
What do you say, Mr. Day after
day
tomorrow?
after tomorrow
The phone over phone you try.
no through letter and DCP
A letter you can't expect.
no over phone I have discussed with DCP Friday also even that they are not providing information I will
Now why it is DCP? It is rural. It is SP rural.
no Jagatpur
No.
ମାନେ ଆମେ
ଜଗତପୁର ଟା କାହାର?
ଏଇଟା ହଉଛି
jurisdiction of Jagatpur
ହଉଛି ତାର
ଜଗତପୁର ହେଲା କମିଶନରେଟ କୁ।
କମିଶନରେଟ ଆଉ ଯଦି ସାଲେପୁର ହବ ହେଲେ
ସାଲେପୁର ହେଲା
ସାଲେପୁର ନୁହେଁ ଏଟା
ଏଇଟା ହଉଛି ନିଶ୍ଚିନ୍ତ କୋଇଲି,
ନିଶ୍ଚିନ୍ତ କୋଇଲି
ହଁ ପରା।
ହଉଛି।
ବରମୁଳା, ଗୋପପୁର, ପିଏ ସାଲେପୁର।
ସେଇଥିପାଇଁ କହୁଛି ପରା ଏଟା ରୁରାଲ କୁ ପଚାରନ୍ତୁ। SP ରୁରାଲ।
ଏସପି ରୁରାଲ।
ହଁ ଏଟା ନିଶ୍ଚିନ୍ତ କହିଲି ଅଛି। ଯଦି ଭିଲେଜ ପଞ୍ଚାୟତ ଏସବୁ ସେ ଖବର ପାଇଯିବେ।
ଏସପି ରୁରାଲ ମାନେ ଏଇଠି।
And he was a driver ନା?
driver
ତାଙ୍କର ଜ୍ଞାତି କୁଟୁମ୍ବ
ନିଶ୍ଚୟ ଥିବେ।
And easiest way to find out is also PW11 is the wife of the appellant.
Yes.
If they find out
11 is the wife of the accused. And she is staying somewhere in Salepur again.
Right.
According to this history of
no,
the
she is staying at Jagatpur police
Oh,
station.
she is at Jagatpur.
କୃଷ୍ଣଚନ୍ଦ୍ର ତା ନାଁ ହଉଛି କଣ?
କୁନି ବେହେରା।
କୁନି ବେହେରା।
Yes, କୁନି ବେହେରା। ୱାଇଫ ଅଫ
କୃଷ୍ଣଚନ୍ଦ୍ର
କୃଷ୍ଣଚନ୍ଦ୍ର କିଏ?
accused.
ଓ ତା ନାଁ ପରେ ଦୁଃଖା
ଦୁଃଖା alias
କୃଷ୍ଣ
ଦୁଃଖ ଆଲିଆ।
ହଁ ତାହେଲେ ଆଉ କଣ ଅସୁବିଧା ହଉଛି ଆଉ?
ସେ କହିଦବ।
We are just keeping it day after day.
ଆଜ୍ଞା
Sorry, on the request of Land Council for the state, use this method from 14th of August 2025 for apprising this court about the well-being of the appellant. So what? Yes.
Item 7.
Mr. Panda, it is your matter?
No.
No.
7 minutes, I think Mr. Ragada is appearing. Let Mr. B. Panda.
तो name delete कर दो आपको चल।
Hi.
B. Panda is associates.
हाँ.
Singular plan. कितने जन प्लान हैं? 2 जन। Mr. Robert कहाँ पे आप कलर नाम देते हैं? समझते हैं?
Mr. Vijay Ragada, Ellen Patel, came with it. So if the names of let Mr. S.R. matter onwards, we
नहीं, Robert को ऐसा मतलब लाइक तो स्टेट।
S.K.Sahoo Hon'Ble.
हाँ, Mr. Robert, then Lakshmi Narayan Patel,
Ellen Patel.
then
N.K. Das,
N.K. Das, S.K. Muduri। ये 4 जनकर नाम रहुची एवं से अपियर पर्यंत केवल जनों ପାଇଁ ତା ନାଁ ହଉଛି
Rambabu Sahu.
but what about the other one?
Appellant 1.
अच्छा,
the affiliate one to Modi.
हाँ से मर्दी।
Ah,
All right, let's complete. Order कुछ कॉल करो।
Mr. Ragada associate.
परिधि क्यों आ गया? आगू की ना। So 1 and 2 out of the 2 appellants, one is Dave, and whereabouts of the appellant number 2
No,
is
it is
not known.
photocopy of death certificate is already.
अच्छा, there will be quite a lot of one.
Ascertain the genuineness of the death certificate required. Death certificate or genuineness to be required.
24/7/2025 ऑर्डर टा टिके देखिले।
No correspondence has been made with in terms of order.
Mrs. Patnaik, you are in this case. We see the order dated 28 Marco. Order number 42/24/25।
Whether the question is alive or not. That's
No, please read the order dated 24/7. Are you having that copy of the order?
Yes. A specific order was passed on 4/7/2024 when learned counsel.
You come to the 24/7/25 order, the latest one.
Yes, Your Lordship, it is 24/7.
Just so for death certificate
Was produced.
Photocopy, yes, Your
And we have asked you to
in the whereabouts of appellant number 2.
genuineness of death certificate, number 1. Number 2, well-being of appellant number 2.
Yes, Your Lordship.
So these 2 aspects you are to obtain instruction.
Lordship, we have obtained the instruction.
It has come.
Yes.
Please pass. Information. What about Maheshwara? Maheshwara examine ହେଇଛି?
No, ma'am.
Judgment ର ପଛରେ list ଥାଏ।
No, ma'am.
Maheshwara examine ହେଇନି। ଆଚ୍ଛା, ଆଇଥର ପଢନ୍ତୁ।
पैसा आनिबा ପାଇଁ ଗଲି ମୁଁ पैसा ଆଣିକରି ଘରକୁ ଫେରିବା ସମୟରେ ସେତେବେଳେ ପ୍ରିନ୍ସ ହୋଟେଲ ସାମ୍ନାକୁ ଆସିଲି ସେହି ସମୟରେ ଦେଖିଲି ପ୍ରିନ୍ସ ହୋଟେଲରେ ବହୁତ ଲୋକ ଜମା ହୋଇଥିଲେ ଏବଂ ରାମବାବୁ ସାହୁ ମତେ ଦେଖିକରି କହିଲା ମାରେ
Leave it. So Rambabu Sahu is now alive. Okay.
ମାଏ
ଠିକ ଅଛି।
ଏହା କହିବା ଦ୍ୱାରା ସେଠାରେ ଜମା ହୋଇଥିବା ଭୂଷଣ ସାହୁ ତ୍ରିଲୋକ ଯାଦବ ସୁଦର୍ଶନ ଯାଦବ ମୁନା ଯାଦବ ଏବଂ ବହୁତ ଘାସିଆ ଲୋକ ଯାହାଙ୍କର ମୁଁ ନାମ ଜାଣି ନାହିଁ ସେମାନେ ମତେ ଦୌଡାଇଲେ ଏବଂ ମୋର ତିୱାରୀ ହୋଟେଲ ସାମ୍ନାରେ ଧରିକରି ବହୁତ ମାଡ଼ ଦେଲେ। ତ୍ରିଲୋକନାଥ ଯାଦବ ଧରିଥିବା ଏକ ଭୁଜାଲିରେ ମତେ ଆଘାତ କରିବା ଦ୍ୱାରା ମୋର ବାମ ହାତ କହୁଣୀ ପାଖରେ କଟିଯାଇ ରକ୍ତ ବାହାରିଲା ଏବଂ ମୋର ବାମ ଗୋଡରେ ଚୋଟ ଦବାରୁ ତାହା କଟିଯାଇ ରକ୍ତ ବାହାରିଲା। ତାପରେ ସେମାନେ ମତେ ଛାଡିକରି ପଳାଇଲେ। ମୁଁ ଉଠିକରି ଘରକୁ ଆସୁଥିଲି ସେଇ ସମୟରେ ଆମ ପଡାର ଲୋକ ସତ୍ୟେନ୍ଦ୍ର ସ୍କୁଟର ନେଇକରି ଘରକୁ ଯାଉଥିଲା। ମୁଁ ତାକୁ କହିଲି
ସତ୍ୟେନ୍ଦ୍ର କିଏ?
Satyendra, no.
Examine ହେଇନି?
No, my lord, not exam.
No.
Okay, ଠିକ ଅଛି। ତାପରେ
सत्येंद्र स्कूटर लेकर घर को जाऊला मु ताको कहली ये लोग मेरे को भुजाली से मार दिए ले चलो हमको से मते घर को नहीं गला एवं घरु मते आनी करी हॉस्पिटल ले छाड़िला मु वर्तमान चिकित्सा हेउछि ता छडा सेमाने मध्य गुली फायर करिबारु आम पड़ार श्रीनिवास देहरे गुली बाजिबारु से एही डाक्टर खाना रे चिकित्सा पाई भर्ती होइछि।
so that Srinivas is the deceased in
My-
So obviously, one eyewitness is the informant himself.
Injured witness.
Injured eyewitness is the, how many other eyewitnesses are there?
And is there 8 also?
Acha, just PW1 is another and PW8. So 1, 8 and 10, they are the 3 eyewitnesses.
Right.
And 9 also.
9.
9. Okay.
The brother of the deceased.
That is it. One dying declaration is there.
Yes, my lord. That is the exhibit 7.
Yes,
This is
dying declaration page number kete?
this.
199. It is recorded by whom? Doctor.
Doctor.
Please read it out first, dying
Page
declaration.
199.
Who is the doctor who has recorded?
A.N.
Behra, Your Lordship.
Is PW?
This PW.
A.N. Behra. Examination the. How would a doctor say sign person the B.K. Ponda? Any of the doctor has been examined?
Yes, Your Lordship. Yes, Your Lordship. The
Dr.
doctor to
S.C.
the
Behra.
postmortem.
Huh?
Has been- Doctor to the postmortem has been examined as witness number 4.
How it keep?
No, I
A.N. Behra.
S.C. Behra. A.N. Behra.
5 doctor. 4.
No, the person who has recorded this dying declaration, you see in the top, page number 199.
Dr. B.K. Panda.
It is
Assistant
statement taken by A.N.
N.
Behra,
Lecturer
lecturer
of
surgery in presence of B.K. Panda.
PW 5.
PW5. PW5.
Who kiye?
S.C.
A.N.
Behra.
Behra.
A.N. Behra.
Oh, A.N. Behra. So it is PW5. Okay. First read that 199 page of lecture.
Dying declaration of Srinivas Yadav, bed number 28, certified that Srinivas Yadav, 25 years, son of Ramnath Yadav, at Dipupara, Jharsuguda, district Sambalpur, is mentally fit and not under sedation to give his dying declaration. Statement taken by Dr. A.N. Behra, lecture surgery in presence of Dr. B.K. Ponda.
That B.K. Panda has not been examined.
Yes.
Yes, ma'am.
Okay, then read it out. Yes.
Assistant Professor Surgery. The patient was talking in Hindi. The question asked was in Hindi and he replied in Hindi. It was recorded in English. First, his name and address was asked. Secondly, to narrate the incident which occurred to him. The patient stated that his name is Sri Srinivas Yadav, son of Ramnath Yadav, at Dipupara, PS Jharsuguda, district Sambalpur, on Thursday night at about 9 p.m. while he was going on the way to station Chowk, Jharsuguda. Bhushan Sahu and his brothers Swayambhu and Puran Babu fired at him from a distance. He had not any quarrel or talked him. He could not tell the date of the incident. After that, he had severe pain in abdomen and then he fell down and became unconscious. Later on, he came to know that he is at Burla Hospital.
So let us know that who are these 3 persons.
Fine.
One is Bhushan Sahu and his brother Shambabu and Puran fired gunshot at him.
Right.
They were the accused persons. In the come to the judgment, First page, let us see that whether those persons Bhushan Saur upon a acquittal is appellant.
Appellant died.
Dead, actually.
Appellant one.
Okay, dead. Then Sambabu,
Sam one. Minor
this man is Rambabu, not Sambabu. Sambabu, I would have now and Puran. Puran K.
Both were not there. There is 7 person, one Sudarshan Yadav.
No, we are just asking you about the 3 persons named in the dying declaration who have fired at the deceased.
As per time.
Right, as per the
Right.
dying declaration.
So then
One is dead, the other 2 not the accused persons in the before the trial board. So
Yes,
is it correct or not?
Yes, ma'am.
So now let us go to the doctor who has recorded this dying declaration. He is
SC
as
PW5.
PW5.
and Bera.
Will 5T.
Achyuta number.
Page chapter number
Page 146.
1, 4. Achyuta number there. Please come to page 146 and read the evidence of.
Question of witness number 5 for the prosecution
On 7/8.
Declaration को पढ़े.
on
अच्छा,
7/8/1992.
7/8/90,
I was assistant professor, surgical, VSS Medical College, Burla. On that day, Srinivas Yadav, son of Ram Yadav, Dipupada, Jharsuguda, was admitted to the casualty at 9 p.m. in bed on 27 of on bed number 27 of male surgical ward number 1. I found that the following external injuries: one lacerated wound of epigastric about 4 in diameter. One second injury, one lacerated
in diameter, tapre.
Diameter, and second injury, one lacerated wound of about 3 ml in diameter in lumbar region right side, and third one lacerated wound of 3 ml, one diameter of medial side of right thigh 10 centimeter above the knee. That is 3 external injuries. The patient was on 7/8/1992 at 12:20 p.m. to 1:30 p.m. by Dr. B.K. Ponda and by me, and found on opening the abdomen there is the 3 injuries. The pelvic
You come to the paragraph number 3.
minor. After operation, he was treated. 2 bags blood transmission was given at the time of operation, and after operation also medicines and blood transmissions were given. He received treatment as indoor patient till 10/8/1992. He expired on that day at 9 p.m. From the report of radiologist, it appeared that before operation, X-ray of the wounds have been taken, wide X-ray plate number, so and so. After operation, the X-ray of the wound found not be taken as the condition of the patient was bad. The treatment of the patient from beginning till his death contained in the bedhead ticket, which is marked as Exhibit 4, and my signature is Exhibit 4/1. I am acquainted with the signatures of Dr. B.K. Ponda, who has also signed in Exhibit 4 on many occasions. The patient was under treatment on 8/8/1992. I informed OIC Burla PS to make requisition for a magistrate for recording dying declaration of a patient. The OIC intimated that requisition have already been sent for a magistrate, and Dr. B.K. Ponda instructed me to record the dying declaration, who again instructed me to record the dying declaration of the patient. My requisition in Exhibit 5 and my signature is Exhibit 5/1. The reply of the police is Exhibit 6. Thereafter, I recorded the dying declaration of the patient presence of Dr. on 9/8/1992 at 11 a.m. The said statement is Exhibit 7 and my signature is Exhibit 7/1. The patient also gave his left thumb imprint LTI in my presence and the certificate identifying the LTI is Exhibit 7/2. I had observed all formalities before recording the dying declaration of the patient. I satisfied that the patient was in a fit condition to make his statement voluntarily. Then the cross-examination alone. Even after operation taking into the damage condition of the internal organs and the bleeding, we had also apprehension that the patient may die. Therefore, I volunteered to ask the police to requisition the services of a magistrate for recording of time declaration of the patient. He was not given oral feeding after operation till death. He was given food through nasal tubes. The patient might be having pain in his stomach, and as such, diclofenac injection and other injections were given. This treatment had been given to subside the pain and will have sound sleep. TG, Tigicasic injection has been given on 8/8/1992 at 7 p.m. On 9/8/1992 at 9 a.m. He was complaining pain in his abdomen and as such Dislonec injection was advised. The said injection also might have been given. I cannot say the time. On the same day at 11 a.m., Dr. B.K. Ponda also advised for blood transmission and cytolate and injection MBI. At that time of admission, I had not suggested for the recording dying declaration as I did not know what was the amount of damage to the internal organs, etc. It is not a fact that at the time of recording of dying declaration, the patient was not in a fit state to give the statement. The patient made his statement in Hindi. I translated it into English. It is not a fact that I could not understand Hindi in which the patient might have spoken, and as such, my recording in English is not properly recorded. It is not a fact that the pressure of police, I have recorded the statement of the patient which will suit the case.
Mrs. Patnaik, let us say that what was the condition at the time of dying declaration will verify from the bedded ticket. But fact remains that even if prima facie we accept that dying declaration to be true and correctly recorded, then the names of 3 persons find place. One is Bhushan, who is already dead. 2 others are Sambabu and Puran. They are not the accused in this case. Are you,
In PW9 has addressed Puran Ram.
Then it's all right. Who is that PW?
9, Your Lordship, is the brother of Raj Srinivas Yadav, Your Lordship.
PW9. Just a minute.
Rangila. PW9 is Rangila Yadav. Rangila Yadav.
Because ordinarily nicknames are also should have been mentioned in the judgment itself, but that is not there. That this Rambabu Sahu is also known as Puran. But you have found out from the evidence of PW?
PW9, Your Lordship.
PW9. That is at page number?
Page number, Your Lordship, 162.
Sure.
Page
That line is-
165, page 165, para 7, Your Lordship.
165.
No, it is not a fact that accused Rambabu is not addressed as Puran Babu. So it's a positive one.
Yes.
Oh, you must have stated that in the chief examination that Rambabu is also known as Puran. That is why
It is not a fact that I have not stated for the air that Rambabu is called Puran Babu.
even apart from this dying declaration which has been recorded and this eyewitness version of PW9 has also stated in paragraph number 4 that when the deceased was carried to the hospital by a cycle, police came there to the hospital, examined Srinivas about the occurrence, and told the police that accused Ram and Bhushan, they fired at him. After the case of Srinivas, my statement was recorded. So these are the two persons who has oral dying declaration is also recorded, is there by that PW9.
He said that they fired at us.
They fired.
By their gun and pistol.
Shambabu. Who is Shambabu? Shambabu is not an accused.
Not an accused.
And the name of Shambabu has not also been uttered by the PW9. He has specifically stated that two names were stated by the deceased, those who are found guilty and those who have also preferred appeal.
Right.
This in that very paragraph number 4, if you come 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10th line from the top, accused Rambabu is also addressed as Puran Babu, right? So,
In fact, my lord, Schedule 16 and IO, my lord, who examined the Schedule 9, my lord, in his paragraph 9 of his cross-examination, confrontation, my lord, I have examined Rangila Yadav, Schedule 9. It is a fact that he has not stated before me that in his presence, Srinivas told the IO in the hospital which Bhushan and Rambabu fired at him. He has also not stated before me that accused Rambabu is called as a Puran Babu.
which is that line you have
My lord, evidence of Schedule 16, my lord.
1-6, acha.
My lord, paragraph 9.
Just a minute. PW 16's evidence starts at which page?
182.
182. 182.
82. At 180.
This. Is the IO.
My lord, there are
PW 16 IO.
17 also, PW 16 examined Schedule 9.
Who line does the kill?
Paragraph 9, paragraph 9.
Confrontation is who is paragraph 9. Page number?
Page number 184.
184. 184. Acha. Please read it once again.
I have examined Rangila Yadav, Schedule 9. It is a fact that he has not stated before me that in his presence, Srinivas told me, IO, in the hospital that accused Bhushan and Rambabu fired at him. He has also not stated before me that accused Rambabu is called as a Puran Babu.
Okay, but let us say that dying declaration part, oral dying declaration, he has not stated. But what about his version as an eyewitness to the occurrence? What have you elicited in the cross-examination? Because his evidence is specific in paragraph number 3. You come to paragraph number 3 of that PW9 eyewitness.
On that day, in night, I went to Anand Bhavan to deliver meal. I, along with PW8 Ram Iqbal and other came out of Anand Bhavan. At that time, we saw accused Rambabu along with the other were near the Prince Hotel and abusing us by saying such and such. At that time, my brother Srinivas, deceased, came there by his cycle and stood near us. When we wanted to go near the Prince Hotel, stones and bricks bats were pelted at us. Thereafter, accused Ram went to the Durga Mandap and accused Bhushan was standing at a Prince Hotel. At that time, accused Bhushan was holding a small gun and accused Rambabu a small pistol. The gun shown to him were refused to have been used by accused Bhushan and Ram. Thereafter, both accused Bhushan and Rambabu fire at us by their gun and pistol. By that time, my brother Srinivas was wounded as he was sustained
He was standing
before me. On his abdomen and right leg, he got bullet injuries. Thereafter, accused Triloki threw bombs at us, and by that explosion, there was a heavy smoke and
Triloki has been acquitted.
murder.
He was the accused number 2 in the trial.
Soon after, I along with Ram Iqbal and other carried Srinivas to hospital by cycle. Thereafter, police came to the hospital and examined Srinivas about the occurrence. He also told the police that accused Rambabu and Bhushan fired at him. After the death of Srinivasa, my statement was recorded by the police at Burla. On 10/8/92, Srinivas died at Burla Medical College Hospital. Srinivas also told me that he has given his statement before the police. According to Rambabu is also addressed as a Puran Babu. After the inquest was held over the dead body, the Srinivas, a report was prepared. I also signed it.
I have not signed.
I have not signed. But
So the second part of this, which has been confronted, that
Confronted,
is
right.
stated, that
But,
he is saying that he has not stated.
not stated.
But what about the para 3?
Para 3 रे जो कहछंती ए दी
Mosannar jo fire hela,
दी जण जाको गन और पिस्तल धरथिले
injury hela.
माने फायर कले ई जगह रे इंजुरी हला, which of course is getting corroboration from the medical evidence. So what you have in the cross examination to disbelieve this part of the evidence of PW 9 as an eyewitness to the occurrence.
Prosecution, madam. The other accused persons, excluding accused Rambabu, are servants of accused Bhushan. Prince Hotel is about 3 minutes walking distance of a bus stand. On 5/8/92, a report was given to the police about the incident of Rajendra, but I cannot say if any case was started by police for the incident. I was also in the hospital when police came there. At that time, I did not give any written report to the police about the occurrence. Ramagwal, Jitan, and others also were present in the hospital at that time. They also did not give any report to the police about the occurrence. It is not a fact that I have not stated to the IO that
says it.
before me, Srinivas.
এইটা prove করে লামো দেখে এটা হচ্ছে
Say aspect রে
PW 16 পেজটা কেটে কইলেন
Page
এটা prove করলে কথা না
4, para 4.
184, paragraph 9.
পেজ 180
9.
এটা ঠিক আছে। What about this eyewitness जो पार्ट
No, only suggestion has been given. It is not a fact that accused Rambabu is not addressed as Puran. It only suggestions are there. It is not a fact that accused Bhushan was not holding a gun.
Rambabu was holding a pistol.
I am deposing
balls. And paragraph number 9, you come to 5 lines from the top of that paragraph. 1, 2, 3, 4, 5, no, 6th line.
I also then
I also
saw them while they were aiming the gun and pistol pistol to us by us. They aimed and immediately fired. We did not have any time to escape and conceal ourselves. They were directly at Srinivas and myself, Ramikval, Jitan, and others were standing very close to us. It is not a fact that I have not stated to the IO that accused Bhushan fired at us from the pistol.
From the hotel.
Oh, sorry, hotel. before the death of Srinivas, he was also
Operated upon.
upon. Srinivas was
Conscious before
conscious
he was. Conscious before he was.
before he was operated upon. I had also talked with him. It is not a fact that I tutored Srinivas. I tutored Srinivas about the occurrence. It is not a fact that that time. At that time there was a rain and darkness, and for that I have not seen the fire bullet. It is not a fact that
who fired the bullet.
he stated that Bhusana and Rambhav both are my lord aiming to them and fired.
It is not a fact that.
It is not a fact.
Now you come to the ballistic report. The result of examination, that is come to page number 201. You count as CG the land. Number one,
Double barrel, 12 bore.
12 bore gun. That is marked as exhibit A. Then cartridges marked as C/1 to C/10, 10 rounds of jam. Then out a gun CG.
Air gun.
Air gun. जोटाकू मार्क ହେଇଛି exhibit C. तापरे out air pistol C ହେଇଛି जोटाकू मार्क ହେଇଛି exhibit D. तापरे 25 numbers of pellets. Taapore one piece of deformed lid, so on so full pant. Now you come to the result. The exhibit so and so firearm being in working order, number one. No trace of discharge so and so, either so and so, could be detected from the barrel on chemical examination of the barrel was. There is no evidence of recent firing could be, so it number exhibit
marked exhibit I.
Exhibit marked as one so proof 12 bore con mane eta hochi mark as A. Eta hochi first result of examination A. Tapare 10 round of cartridges one so identification of the fire pin. There is 10 rounds of cartridges are of the three varieties. Out of the above three cartridges, some were selected and random. Test firing was conducted, but all the three cartridges were misfired. On opening and examining the cartridges, it was revealed that the cap composition deteriorated. So the cartridges are inactive. Now the exhibit marked as one so air gun. Eta hochi air gun ka mark heichi as exhibit. Air gun ka mark heichi C of the exhibit C of the air gun air pistol. Air gun right. Now air pistol is D CD. Both are in working order to propel so and so. Test firing conducted with these two exhibits to deal with this answer. From the distance of about so and so, it is observed that none of the pellets would be penetrated. Target four. Thus, the exhibits so and so cannot be classified as firearms. In both of the exhibits, there is no device to propel the projectile due to expansive nature of gases being generated by some combustion if lead action.
No traces of discharge residue. Can I see that? Let me see effectively. But
डॉक्टर तक ये माने जो ये परिचय आउट करे
46 page.
Who has conducted the
Yeah.
PM?
PM का ये करो.
Schedule 4.
PW4.
4. 4 is Jitendra Kumar, right?
No, this is not 4.
Or Dr. Jitendra.
52.
Mhm.
5 doctors have been
No, we have one is dying declaration, the other is.
examined.
A surgeon.
PW4 is the doctor who conducted PM, right?
Yes, Your
There
Lordship.
was once a different stage to wound, right? There's some midline standing of clinical life in upwards. This.
This conclusion which he has arrived as page number 145, that shows that it's a firearm injury and the death has taken place on account of that. Yes. So some bullets were also
Projectiles have been
uh,
found, yes.
So that was taken out and that was
Preserved
kept
envelope.
in a envelope sealed and it was sent. So that means so far as the date is concerned, it remains unassailed that the death took place on account of firing.
Non-certain.
Because you have not even elicited anything and not even suggested to the doctor that no, the death was not possible by it. So if that part remains unchallenged, then comes the eyewitnesses statement and also the doctor who has recorded the dying declaration. Dying declaration, in fact, it is named 3 persons. Out of 3, 1 is dead. The other is Rambabu, who is known as Burandev. The third person, do not know Sam Babu, who is he, but he has named 3. But the eyewitnesses, as we find, you have read one eyewitness, that is PW9. From that evidence, it appears that 2 persons fired.
Yes.
Who are also named by the deceased.
Yes.
That is Bhushan and Rambabu. Bhushan is dead, Rambabu is. Who are the eyewitnesses? Apart from PW,
8, 11, and 12.
then come to PW8, let us see.
156.
Please place it.
I know the accused person, so also Srinivas Jadhav disease. I also know the injured, namely Singhasan Jadhav and Hemant Kumar. I also know Meena Singh and Dhiren Singh. In between Dhiren Singh and Meena Singh, there was dispute and litigations for property. Bearing myself, all other witnesses are Goala by caste. The Goala people were supporting Dhiren Singh. According to Bhusana and Ram, were supporting Meena Singh. Both the accused persons are brothers. All other accused persons are their servants. Accused Ram as a hotel and accused Bhusana is the owner of a house for the buses. For aforesaid reason, the accused persons were pulling on oil with the Goala people. On 6/8/92, at about 9 p.m., the occurrence took place on the main road in between Anand Bhavan and Prince Hotel. Just before the occurrence, I was at Anand Bhavan. After delivering milk in the Anand Bhavan, when I came out, I saw all the accused persons standing near the Prince Hotel belonging to accused Rambabu. They were also abusing, saying, speech language. At that time, about 10 to 15 Goala, including the witnesses present near the Anand Bhavan. At that time, the accused persons had started pelting stones at the Goala people. Soon thereafter, accused Ram went to the Durga Mandap with a gun and Bhushan was holding a pistol. Accused Triloki was armed with a knife. Both accused Ram and Bhushan fired at the Goala people from their gun and pistol. Out of the Goala people, Srinivas deceased was hit by bullet, one at his abdomen and the other at his right leg. Thereafter, bombs were blasted, but I cannot say who threw the bombs. Thereafter, by the smoke of the bombs, as there was a darkness, I entered inside the Anand Bhavan and concealed myself. I have not seen at the time any other getting injured. Subsequently, I heard that accused Terloki also assaulted Srinivas by a knife.
Singhasan by a knife. Singhasan, mane informant.
Srinivas was removed to the hospital. 4 days thereafter, I came to know in the jail that Srinivas died. The gun and pistol shown to the witnesses were not used by accused Ram and Bhushan in the assault, as said by
the witness.
On 6/8/92, I was examined by the IO at night. Prasansam. Singhasan Yadav, Rajesh Yadav, Kailash Yadav, Indradev Yadav, Rajendra Yadav, Girdhari Yadav, Ram Iqbal Yadav, Rangila Yadav, Ram Kripal Yadav, Dilip Yadav, Lal Bihar Yadav are residents of Dipupada, Jharsuguda town. I am staying at a Gurumal. I am also selling milks. Goala Rangila is the brother of the deceased. Kailash Yadav is the son of Rangila. Ram Iqbal, Ram Kripal are the first cousin of Rangila Yadav. Prince Hotel and Anand Bhavan are one side of the road. In between the Anand Bhavan and Prince Hotel, there is a Sharma Lodge. One lodge of Anand Bhavan and one hotel whose name I can't say. Tiwari Hotel is besides Anand Bhavan. It is not a fact that because the Goala people pelted stones at the Prince Hotel. By that, the glass almirah of the hotel and showcase were broken. On the allegation that we have pelted stone at the Prince Hotel, a case has been started in which I am an accused. Beside the two groups, the names of whom I have said above. There are also some Ghasia people standing in front of the Prince Hotel at that time. It is not a fact that I have stated before IO that there was exchange of abuse between both the groups by saying such and such. From the Tiwari Hotel, there is a road to the railway station. The area between Tiwari Hotel and Prince Turn is usually crowded till 10 p.m. in the night. In that night also, many people were passing on the road at the time of occurrence and the place were crowded. Srinivas was standing 6 to 7 cubits away from the Prince Hotel. I was standing on the veranda of Anand at that time. Indradev, Giridhari and others were standing close to Srinivas. Accused Bhushan fired from the Prince Hotel and accused Ram of fire from Durga Mandap. During Durga Mandap is in front of Prince Hotel on the other side the road. It is not a fact that I have not stated before IO that accused Ram of fire from his gun from Durga Mandap. It is not a fact that I have not stated before the IO that accused Bhushan of fire from the Prince Hotel. I do not remember if I have said before the IO that both accused Bhushan and Ram fired 2 to 3 rounds at the Goala people without mentioning the place from where they fired. I had not been to the hospital at Jharsuguda. As after the occurrence, about 1 hour after the firing was made, police came to the spot. When police came to the spot, I told him about the occurrence. No effort was lost by me with the police at the spot. What I said to him about the occurrence also not recorded. I do not remember if I have said before the IO that due to blasting of bombs there was darkness in that area due to smoke. It is not a fact that we Goala people pelted stones and bricks bats at Prince Hotel. It is also not a fact that I do not know anything about the occurrence, as at that time there was a raining and I have not seen as to who fired to darkness. It is not a fact that as I am also one of the Goala people, I am against the accused persons, I am deposing falsely. Further consumption, recall. It is not a fact that I was not in the position to identify the firearms used in the occurrence. It is not a fact that accused Rambabu was not holding a pistol and accused Bhushan not holding a gun. At that time, I am deposing falsely. It is not a fact that I have not stated before the IO that they pelted stones to us and accused Tarluki was holding a knife and I am deposing falsely.
This confrontation part which you have put will come to page number 193. That is the IO's evidence. IO is PW 18. He is another investigating officer. So see that what you have put.
190.
Got it?
On 6/8/92, I was SI of police, Jharsuguda PS. On that day,
come to paragraph 12, page 193. Page 193.
I have examined
PW8.
It is a fact that he has stated before me that accused Rambabu and Bhushan fired 2 to 3 rounds towards Goala people from their respective gun and pistol without mentioning the places, Durga Mandap and or Prince Hotel. From no brick bats were found in the front of the Anand Bhavan and also at the place situated in the between Prince Hotel and Anand Bhavan. PW8 has not said that the accused persons pelted stone. They also said that men of Rambabu pelted the stones. I have not examined Rangila Jadhav PW9 and Ramankal Jadhav PW12. I have examined in Indradev Jadhav PW11. It has not said before me that Rangila and Jiten took Srinivas and one scooter wala took PW10 to the hospital. It has not said before me that particularly accused Bhushan fired at the Goala people from his Prince Hotel. I have seized the cycle on 6/8/92 at about 11:15 p.m.
So if you read this evidence of this eyewitness, The occurrence no doubt took place in the evening hour, 9 p.m.
Madam.
on 6/8/92. But if you the sequence of events, the first it appears that there was pelting of stones. Then the firing took place, and then this bombs were. So you are perhaps taking a plea that there was darkness because of that smoke of the bombs which were blasted,
And also raining.
for which they could not have been able to see the persons who fired at them. But come to page number 157 once again, page this PW8's evidence. You see the sequence. 1, 2, 3, 4, 5, 6, 7, 8th line from the top.
At that time, accused persons first started pelting stones at the Goala people. Soon thereafter, accused Ramo went to the Durga Mandap with a gun, and Bhushan was holding a pistol. Accused Tarleki was armed with a knife. Both accused Ram and Bhushan fired at the Goala people from their gun and pistol. Out of the Goala people, Srinivas, deceased, was hit by bullet, on one at his abdomen and the other at the right leg. Thereafter, bombs were
So
blasted.
thereafter means after the
After the firing.
So you are giving the suggestion that on account of bomb blasting there was smoke, and so that
That
took
came later.
place.
That came later.
So
And after that, bomb blast.
now we have at least covered two eyewitness statements. So both of them have implicated consistently that it was these two accused, that means the two appellants in this appeal, those who have fired gunshot at the deceased. And this is, we have to take coupled with the medical evidence, that means the doctor who has conducted PM examination. So also the dying declaration. Dying declaration, one thing is that one name has been
One more
added,
name is there, which is not there.
which is not there.
So that is why probably court has, the charge sheet has not been given.
So these are the another witness. So 8, then we read it 9, another witness
11 and 12. yeah.
11 and 12. Come to those two.
11, your lordship, page 170.
No, Singhasan himself is there. Is there, that we have read. He is the informant. Now 11.
170.
Read it down.
I know the accused persons in the dock as well as the deceased. I am a Goala by profession. On 6/8/92 at 9 p.m., the occurrence took place. At that time, I had been to the station chowk, Jharsuguda. I saw Goala people, including PW8 and 9, Ramkripal, Jiten, and some other were standing in front of the Anand Bhavan, in front of the Prince Hotel. Accused Rambabu, Bhushan, accused Tarleki, and other accused persons were standing. The accused persons were abusing the Goyal people. Thereafter, thereafter they also pelted stone at the Goala people. Thereafter, accused Rambabu came to the Durga Mandap. He was then holding a pistol. Accused Bhushan was standing on the road, on the road in front of the Prince Hotel with a gun in his hand. Thereafter, both accused Bhushan and Rambabu fired at us. Srinivas was standing before the grocery shop of Moti near Anand Bhavan, about 15 steps away from the accused persons. Near him, Jiten, PW9, Ramgwal were also standing along with others. By that firing, Srinivas got bullet injury on his abdomen and right leg. Soon thereafter, accused Tarleki threw a bomb at us, which was exploded.
This is again after the bullet.
After the bullet by smoke.
By the smoke caused by the blasting, there was
and we are not able to see. Srinivas got bleeding injuries and his clothes were stained with blood. I did not notice if the spot was stained with blood. PW9 and Jiten and others took Srinivas to hospital. Subsequently, I came to know that again I have seen accused Tarleki assaulting PW10 Singhasan by a knife. Later on, I heard that Srinivas died in the hospital. Prasanna. Pedal 10 is a resident of Dipupada with his mother and also a woman who are staying at that time. She might be the wife of Pedal 10. On that day, I alone came to the spot. I had not been to the station in that night. I had no talk or had opportunity to talk with Pedal 8, 9 and others. They threw many stones and brickbats on us, the numbers of which I can say. Seeing the pelting of stones, none of us fled away, but we came to the side of the road nearer to the shop situated there. We did not raise any holla protesting the action of the accused persons by saying as to why they were pelting stones. I stood near the shop adjacent to the shop of Moti, very close to the door of that shop. I cannot say in detail as to who stood here at that time. After the bomb blast, I went towards the Puspak lodge and went inside that lodge. From that lodge, saw accused Tarlake assaulting Pedal 10. After that, I did not go to the PS to give a report on one scooter wala, whose name I cannot say, took Pedal 10 from that place. Pedal 9 and Jiten took Srinivas to hospital. At about 11 or 11:30 p.m., I went home alone. On the following day of occurrence, I was examined by the IO. It is not a fact that I have not stated before the IO that Pedal 9 and Jiten took Srinivas and a scooter wala took Pedal 10 to the hospital. It is a fact that I have not said before the IO. Rambabu went to the Durga Mandap with a pistol in his hand, and from that place he fired. I do not remember if I have not stated before the IO that accused Bhushan fired from his gun by standing near the Prince Hotel. I have not said before IO that Srinivas was standing about 15 steps away from the accused persons. As I was not asked about this fact by him, I have also not stated before IO about the place where assault was made on Pedal 10 by accused Triloki. It is not a fact that on that day, all of us, being armed with sword and other weapons, went to the Prince Hotel and pelted stone at it, and also abused them inmates of the hotel. Also by the pelting of stones, and almirah and glasses pans of the hotel were damaged. For that incident, a police case has been started against me and others. It is not a fact that on that day there was a rainfall and darkness, and for that I have not seen anything about the occurrence. It is not a fact that as I have been made an accused in the counter case, I am deposing falsely. As I was not asked by the IO, I have not told him that accused Tarlaki threw bomb at us. After we were taken to the PS on 7/8/92, we were told that a case has been registered against us, and there are only I was examined about this case. It is a fact. It is not a fact that I do not know anything about the occurrence of this case and now deposing falsely.
Now, this confrontation which you have made, that has been proved to the IO PW 18, page number 193, paragraph 14.
I have examined Indradev Jadhav PW 11. He has not said before me that Rangila and Jiten took Srinivas and one scooter wala Pedal 10 to hospital. He has not stated before me that particularly accused Bhushan of fire at the Goala people from the Prince Hotel. I have seized the cycle on 6/8/92, 11:55 p.m. I have not directed my investigation to know who were the owner of those cycle and milk cans.
So this part of PW11 and that this one was holding a gun. That is both Rambabu and Bhushan. They were holding guns and one was holding the pistol. Pistol was held by that Rambabu. Bhushan was holding a gun, and they fired. And Srinivas was standing near the grocery shop, and when they fired, Srinivas got bullet injuries on his abdomen and right leg. So this part, and then this bomb.
Bomb blast.
So again, if we see that the cross-examination, whatever contradictions you have brought out, that is no way affects this evidence that who were armed with pistol and gun and fired at the deceased. That is the main substratum.
That is the material particular.
This is consistent. What maybe that is also the or of the London trial court has in that way assessed the evidence, because on this particular part the evidence is consistent as to who fired gunshot at the deceased. So and any other witnesses have been left out as eyewitness? Please read it.
Page 174.
174. Okay. I dealing with Mill. I also know Dhirendra Singh about the affair of Dhirendra. I do not know anything. On 6, I do not know anything. On 6/8/92 at about 9 p.m., the occurrence took place near Station Chowk before Prince Hotel. At that time, I was present in the Anand Bhavan. After delivering milk in the Anand Bhavan, I came out and was standing before the shop of Moti. Many Goala people were also standing at that place. The accused persons identified also were standing before the Prince Hotel. Thereafter, Srinivas came there and stood before us. The persons were standing about 15 feet away from us. Accused persons thereafter shouted at us by saying such and such, and thereafter started pelting stone at us. Accused Rambabu went to the Durga Mandap while accused Bhushan was standing before the Prince Hotel. Accused Bhushan was then holding a gun and accused Rambabu a pistol. Both of them fired at us. By that firing, Srinivas got a bullet injury on his abdomen and right leg. He thereafter shouted and fell down. Thereafter, I, Pidol 9, and Jiten tied his wounds by napkin to check the bleeding and carried him to the hospital by a cycle. Accused Tarluki then threw a bomb, and by blasting up the bomb, the area was covered with smoke and the people assembled there were dispersed. From the Jharsuguda hospital, Srinivas was taken to Burla Medical College Hospital on 10/8/92. Srinivas died in the hospital in the night. Cross-section. On that day, I had not been to Godbhaga. At about 9 p.m., I used to deliver milk at Anand Bhavan. About the delivery of milk, a diary is maintained and that is kept with me. I have not shown that diary to the police. It is not a fact that I have never delivered milk at Anand Bhavan and I was deposing falsely. In front of the shop of Moti, a Punjabi hotel called Anarkali. After the pelted stones, we tried to go inside the Punjabi hotel. Srinivas also was there at that time. Punjabi hotel is about 4 to 5 steps away from the Anand Bhavan on the same side of the road. While we are trying to escape, the bullet hit Srinivas at about 11 p.m. We left the hospital for Burla. I do not know if police came to the hospital before we left for Burla, as I was busy in the medicines. At Burla also, when Srinivas was admitted and documents in that regard was being prepared, I was present there. In the next morning, I came back to Jharsuguda at that time, I did not go to the
PS to give report.
give report.
As I was
in a hurry. On 8/8/92, I again went to the Burla. On 7/8/92, I sent money to Burla. I was examined by IO. I have not said before the IO that at that time, the accused persons were standing 15 feet away from all.
By courtesy, I call
mother of widow 9 and a maternal aunt. It is not a fact that I have said before the IO that widow 9 is the son of my maternal aunt. It is not a fact that at that time of occurrence I was not present at the spot. I have not been
and that I have not seen
the occurrence. It is not a fact that I am deposing falsely as widow 9 and this are related to me. In the night on 11/8/92, we brought the dead body of Srinivas to Jharsuguda, and on the next day cremated the dead body at Jharsuguda at the burial ground near
Ivy River.
Come to the contradiction, page 184. PW 16 is the IU, paragraph is 10. Page 184.
10. I have examined Ram Iqbal Singh, PW 12. It is a fact that he has said before me that a Rangila Datta PW 9 was the son of his maternal aunt.
This is the only contradiction. So now, Mr. Progad, in view of the consistent statements of the eyewitnesses, coupled with the medical evidence and the dying declaration, how do you say that the Land Court has committed illegality in convicting you as well as the person who is dead? We are not concerned with now. So, what is your grounds of challenge? How do you assail the evidence of the eyewitnesses? You now placed almost all the eyewitnesses.
In fact, my lord,
because we find, except that one name has been added in the dying declaration, practically nothing is there in the has been brought out in the cross-examination of this PWs 8, 9, then 11 and 12. These are the Mrs. Patnaik, these are the 5 witnesses. So
even if we exclude the ballistic report,
ballistic export, and that
we exclude it. That is not inconsistent with this.
8, 9, then 11 and 12 are the eyewitnesses, and the dying declaration recorded by Dr.
PW5
and PM Dr. PW
6, your lordship.
6.
4, your lordship. 4.
Jitan
Nitin Ballam, PW 4.
So let us know that what is your preparation, how do you challenge the assail the evidence?
Now, in fact, my lord, do I have today, my lord, we got the received brief, my lord. 10 minutes scattered, my lord, the brief, my lord.
Paper book aji paile
No, paper thila ame pusta
kholi nathile
earlier on
nathile kon client as nathila boli na
exactly that is the for that I have to know, my lord, about the incident from the the accused, my lord, who is alive, my lord. But in fact, my lord, another, my lord,
no ସେ ତ କାମ ପଡି ଯାଇଥିଲେ ତାହେଲେ ଆମର ବି ହାଲକା ହେଇଯାଇଥାନ୍ତା ଗୋଟେ ଯାଇଛି ଆଉ ଗୋଟେ ଯଦି ଯାଇଥାନ୍ତା ବାରି କିନ୍ତୁ but now surviving, now we have to give the judgment.
my lord, so I would chance there much ready.
ନାଇଁ ଚାନ୍ସ ମାନେ ଲଞ୍ଚ ପରେ ରଖିବା ନା next month ତ ଗୁରୁବାର ଦିନ
first case as
Your lordship may keep it to the next week. I won't be personally inconvenienced from next Thursday.
personal testing, yes, sir.
Next Tuesday.
we'll close on that day.
Yeah. We'll close it.
Files
Prepare it,
We'll
your
close it.
note, whatever citation you want to say. Just give how you can overcome the evidence of these four eyewitnesses.
Exactly.
8, 9, 11, 12. The time declaration recorded by 4 and the evidence of PW4, the PM doctor, which corroborates the evidence of the eyewitnesses. That much you can say.
But one thing, the admitted fact that the FIR not instantly, one day after the FIR was lodged. That since a medical legal case, neither police, the doctor informed the police, nor the.
No, doctor has informed the police. Doctor has informed the police.
FIR registered one day after the occurrence.
Doctor has informed the police on the next morning.
And deceased died subsequently married after 4 days. Deceased died married. That
The
part,
occurrence took place on what date?
There are 5 doctors.
Let us record it also.
6, 8.
Date of occurrence is
6, 8.
6, 8,
92.
1992. And the date took place when? 10/8/1992. And this DD was recorded on what date? PW5.
For operation of the next day.
7, 8, 92.
7 तारीख दिन रखा।
Fact remains, the doctor Pidol 21st he has admitted the deceased. Then thereafter Pidol 13 is another doctor who has attended the government hospital. Then the surgical doctor, that is the Pidol 5 on 7, 8, 92 their diagnosis are recorded and this
Perform the surgery.
No, this
That's why there is
this occurrence took place on 6,
6.
and the FIR was lodged on the spot itself on
Yes,
6,
sir.
8, 90.
Yes.
Why are you saying that it is a delay? You come to the what is that called? Formal FIR. You come page 78.
At about 11 p.m.
Why are you telling that next day?
6, 8, 92 at spot, 10:30.
So रात्रि 9 टारे लिखा है चीज page 78%. Now you just see it so that you can perhaps you are a wrong notion that it was lost on this day. But you come to page 100, 6, 8, 92 at about 9 p.m. वाला date and hour of occurrence. तापर देखो
10:30 AM.
At 10:30 AM is next day registration ହେଇଥିବ at 7 AM.
spot रे दिया है FIR सेटा जाएगी नहीं registration ହେଲା
Eight,
बोल
10, तार दिन।
है ना?
That is equal to 10:30 AM. Next day. 7 say no.
So it was lost on the very day and within few hours. It may be
the immediate treatment has been made and thereafter after the surgery the deceased has died. 6, 7
there is no problem. This
Lordship, I would be pardoned, the Lordship.
because it might be so that we do not know that how this who is this Sambabu, because the person the other person might not have noticed also. He might be in a position to notice that who actually fired at him.
Yes,
So accordingly,
because he died, we are not able to know.
but these persons saw that these two persons are in the front.
Yes, Your Lordship.
Might be that Sambabu is somewhere else to whom the deceased has
Could
marked,
see
which has not been marked by the.
any other.
So that may. By the way, Sambabu has not been charge seated. He has not faced trial, and so. But it appears that Sambabu is the brother of that.
The Rama and Bhushan. All are 3 brothers.
They are 3 brothers. Bhushan
Sam,
and his brother
Rambabu.
and so on. So all the 3 are brothers.
they are connecting Rambabu as a Puran.
Now that is there.
If
That is there. Puran is Rambabu, that evidence has come. But who is that Sambabu? That is not. କାହିଁକି ନା ଟେକା ପଥର ଯେତେବେଳେ ଫୋପଡ଼ା ହେଇଛି ସେତେବେଳେ ସେମାନେ ବି ବିଭିନ୍ନ ଜାଗାରେ ରହିଯାଇଛନ୍ତି ରହିକିନି ସାଇଡ୍ ହେଇକିନି ଦେଖୁଛନ୍ତି ବର୍ତ୍ତମାନ ସେତିକି ବେଳେ ଡିସିସ୍ଡ
सामने
सामने अछंती किए को पोजीशन ने सी मार्क करछि ताकू 3 जण फायर करछन सेति पई सी कहला बट ए जो माने नुचिकिन रहिछंती they might have noticed only 2 persons so the third person name which is there in the dying declaration
did not.
that no way improbabilizes that he has added one name who is that person not
That are the most specific evidence whose bullet hit on the DC.
no you see there is no
Both of them
evidence
had.
that any fourth or any third person even
was there.
who holding any
Gone to fire.
gun. You have not brought out in the cross examination that any person other than these two were armed with gun or they caused the এই সব টাইপ র কেস রে কোন কি সেগুলা তো অনা যায় ক্রস এক্সামিনেশন রে যে অন্য মানক হাতে রে ସେମାନେ ମଧ୍ୟ ତ ଯୋଉ ଇଏ ଯେ କିଏ ତା ଦେହରେ ଏତେ ଲୋକ ଗହନ୍ତିଲେ କିଏ ଫୁଟେଇ ଦେଇଥିବ
ଏଟା ତ ସ୍ପେସିଫିକ ହେଲା
ଆପଣଙ୍କର ନାଁରେ ସ୍ପେସିଫିକ ଆସିଗଲା
ଏ ଦୁଇ ଜଣ ନା ସ୍ପେସିଫିକ କେସ୍
ତେଣୁ ସେଠି ଆପଣ ସେଠି
one bullet injury is sufficient just hit on the abdomen
ତ ଦିଟା ତ
ଦିଟା ଦୁଇ ଜଣଙ୍କଠୁ ଗୋଟେ ଗୋଟେ ଯାଇଛି ନା କଣ ସେଟା
2 persons fired from their
It's
pistols.
also said that it has penetrated in and out. It has
ନାଇଁ ନାଇଁ ତା ଦେହରୁ ଗୋଟେ ବାହାରି ଯାଇଛି
ବାହାରି
ଆଉ
ଯାଇଛି।
The liver.
ଆଉ
ପ୍ରୋଜେକ୍ଟାଇଲ
ରହିଯାଇଛି
Yes,
ରହିଯାଇଛି
it ରହିଛି
ତାକି
କିନ୍ତୁ
ସେମାନେ
ବାହାରି।
ବାହାର କରିଛନ୍ତି ମଧ୍ୟ ପୋଷ୍ଟମର୍ଟମ ବେଳେ ବାହାର କରିକି ଇଏ କରିଛନ୍ତି
Pardon, Your Lordship, this Thursday I'm there.
Hmm?
This Thursday I'm there, Your
Yes,
Lordship.
then we can take up there is no problem. You see the Bali report, it of course it does not say that the bullet was tested and then no positive opinion has been given. But after all, it is to be seen that
Yes.
who has produced the arms. So suppose you might have been producing such type of arm which
Which
no
is-
way related
Yes.
to the deliberately,
Deliberately.
just to misguide you,
Hmm.
right? So that may be possible. So ଆପଣ ଯଦି ହଁ ସେଇ ସ୍ପଟ ରେ ଧରା ହେଇଥାନ୍ତା ହେଲେ ଆପଣ ସେଇଠୁ ଆପଣଙ୍କ ହାତରୁ ଏଇଟା ନିଆ ହେଇଥାନ୍ତା ଏବଂ ବାଲିଷ୍ଟିକ ଏକ୍ସପର୍ଟ କହିଥାନ୍ତା ଯେ ନାଇଁ ଏଥିରୁ ଏଇଟା ଫାୟାର ହେଇନି matter would have been different. But since at your instance the arms were seized,
So you might
it
have
might
given
be
a
that
different one.
to misguide you have produced another so we are keeping it to day after tomorrow.
Day after. I'm happy to show that also.
No, it's all right. It will come up fine. Let's see the Mr. Your Robert and Madam का नाम भी लिख दो. Oh my God, this is not.
Prondas chamber file came.
This of the-
Brahman Pandas.
This is not. ମୁହଁଟା କଟି ଯାଇଛି.
ଆମେ ବି ଜାଣିନୁ
whole exercise.
କେବଳ ମାନେ ବ୍ରହ୍ମାଣ୍ଡ ପଣ୍ଡା ଏକ୍ସପର୍ଟ କଲା ପରେ ତାଙ୍କ ଆସିଲା ଆମେ ସେ ଭାବିଲୁ ତାଙ୍କୁ ସମ୍ଭାଳିବୁ
This is a matter before some other bench is which one of us justice S.K.Sahoo is not done. See the
ନା ଆମେ ଜାଣିଛୁ ଦେଖିନି ଭଲ
2 ଘଣ୍ଟା ହେଇଗଲା.
ଯେହେତୁ ଆମେ ତାଙ୍କ ପାଖରୁ ଆସିଲା ବ୍ରହ୍ମାଣ୍ଡ ପଣ୍ଡା ଚାପରୁ ଆଣି ଜିନିଷଟା ଆମକୁ ଦେଲି
I will pardon you, Lord. Item 5. Let matter that you have received the report that Biju Patnaik air ashram se jaiki abo return kali. Biju Patnaik open ashram ru.
No, he has been released.
No,
Then he is absconded.
How he came to the village?
released from the
ନାଇଁ ଜାମ୍ମୁ ଝରିରେ ଯୋଉ ଥିଲା
my lord.
he went away.
25 दिन 2010 ରୁ 3-4 10 ଦିନ ପାଇଁ ଯାଇଥିଲେ.
ତାପରେ ଆଉ ରିଟର୍ନ କଲା ନାହିଁ.
And moreover, the appellant number 2, Joy Prakash Laguri, security ମଧ୍ୟ ନେଇଛନ୍ତି.
This will not serve our purpose.
ଆରେ ଆମେ ଚାହୁଁଛୁ ଆପଣ ଗଲେ କେମିତି ସେ ଗାଁକୁ କାହିଁ କେମିତି ଯାଇଛନ୍ତି ତାଙ୍କ ରେକର୍ଡ ଆପଣ ସେଠି କଣ ଦେଖଉଛି ସେ ରିପୋର୍ଟ
ଜଣେ ଜଣେ 10 ଦିନ ପାଇଁ ଯାଇଛି ଆଉ ଫେରିନି।
ଫଲୋ କରାଯାଇଛି ଫଲୋରେ ରିଲିଜ
ଫେରିବା କଥା
ଫେରିବା ନା
ଗାଁରେ ଯାଇ ରହିଗଲା କେମିତି?
ନରେଶ ଲଗୁରି
This is insufficient.
କିଛି ବି एकदम confusing. He is talking about appellant number 2 or 3. He is talking about both.
Both କହୁଛନ୍ତି ତ ଇଏ
Both.
ତା ପାଇଁ
ଜଣେ ତ ସିକ୍ୟୁରିଟି
ଜଣେ ସିକ୍ୟୁରିଟି
ହେଇକି ସେ ତ ନେଇଗଲା.
ସେ ଯାଇଛି ଆଉ
One of the appellant becomes the surety for the other.
ତାଙ୍କ ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା କରନ୍ତୁ ଯେ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ସାଙ୍ଗରେ ଆପଣ ଯଦି 10 ଦିନ ପାଇଁ ଯାଇଥିଲା ବର୍ତ୍ତମାନ ତ ସେ ଗାଁରେ ବୁଲୁଛି ଆଉ କେମିତି କଣ ଚୁପଚାପ ବସିଗଲେ କେମିତି? ପଲବରେ ଯଦି ଗଲା ଯଦି ଇମିଡିଏଟଲି ନ ସରେଣ୍ଡର କଲା ଇଏରେ ତ ଇମିଡିଏଟ ଷ୍ଟେପ ନେବା କଥା ନା ତାକୁ କରିବା ପାଇଁ।
Unfortunately, he has not surrendered himself till date before the ashram authorities after availing the said furlough leave. In this connection, several causes were issued to the ये तो बाहर बुलुची बोली इंस्पेक्टर हमको रिपोर्ट दउची अब सेठ को नहीं पारुनी.
You clarify, we are mentioning about this later. What gala say? एटा की डिक्टेशन नहीं थी ना किसी ने कहीं हां साबों को इट ऐड कर दूंगी हां से यूटा ऑर्डर हमें कर दिए
लेटर पे letter written instruction has been submitted. दस रु पुणी गलानी 2010 25 ହେଇଗଲାଣି 15 ବର୍ଷ ସେ ବାହାରେ ଫଲରେ ଯାଇଥିବା 10 days ପାଇଁ and whereabout and he is traceable police but has not been taken back.
ये हमें से दिन ऑर्डर पे जो 31/7 रे मेंशन करछु second as per the order dated once so you give the written instruction from the IIC Champua which shows that appellant number 2 appellant number 3 appellant number 5 are in the village and they are in good health condition staying in their houses. This is the report dated 16/7/2025 तो आपनकर जदी एटा होची जे 25/3/2010 रु 3/4/2010 पर्यंत जणे केवल गला appellant number 2 आउ अन्य जणे ता पई सिक्युरिटी थिला से अन्य जण को गला केम हम तो रिजेक्ट करथि तापर द्वितीय कथा सी जदी 2010 पर्यंत तार फॉलो सरी गला आउ surrendered not himself very casually लिखा है he has not surrendered himself before the ashram authorities. That man is enjoying life in the village and no step has been taken. Just clarify that. In the order dated 31/7/2025, there are Sahoo Hon'Ble we have mentioned the report produced before us by the Learned Counsel for the state from Inspector in charge of Champua Police Station dated 16/7/2025. Where it is mentioned that appellant number 2, where is mentioned inter alia that appellant number 2, Jamadar alias Jayaprakash Laguri, and appellant number 3, Nanu alias Naresh bracket Janda Laguri, are in good health condition and staying there in their houses. And they are of village Tonda Gutu, PS Jagannathpur, this West Chingbum bracket Bihar. When we found that they have not been granted bail in this criminal appeal, we asked the Learned Counsel for the state to obtain specific instruction relating to appellant number 2 and 3 as to how they came to reside in their village when no bail order has been passed in respect of those two appellants. Today, the Learned Counsel for the state has produced the letter dated 7/8/2025 received from Superintendent Biju Patnaik Open Air Ashram, Jamujari, wherein it is stated as follows, Purata quote for them, in inviting to Swanson. It is not understood as to how the appellant number 3 was allowed to be guilty for appellant number 2, and if after the furlough leave period expired, the appellant number 2 did not surrender, what steps have been taken by the Air Ashram authorities for his apprehension, and how appellant number 3 was released from the Air Ashram. The Learned Counsel for the state shall obtain clarification on all these aspects from the concerned superintendent and apprise this court on the next date. So which is fixed to, we have already fixed it to 14, so let it be on 14. We are handing over a copy of the order to you during.
May I please
ଆପଣ 14 ତାରିଖରେ ଚେଷ୍ଟା କରନ୍ତୁ, ଯଦି ନ ଆସି ପାରିବ we take it.
Sir, ଏଠି person actually try to bring up more of the food of the
ଅଛି ଆମ ଡକ୍ଟର ଭିତରେ
ନା ଏଇ ଯୋଉଟା ଦେଖିଲେ ଏଇଟାକୁ ମୁଁ ଫାଇଲ କରିଛି
ଦେଖିଲେ ଫାଇଲ ଯୋଉଟା ଆଇଟମ ନମ୍ବର 7 ହଁ ମୋର ଚାମ୍ବର ସମ୍ଭବ ଥିବ ନିଶ୍ଚିତ now ସମସ୍ତ ନାଲେ ପାଇକି ମୋର ଆସୋସିଏଟ ମାନେ ତାପରେ ଗଲା B ଫାଇନାଲ SI no objection ଦେଇଦେବେ 512 ନାଇଁ 512 ନାଇଁ ତାକୁ ଟ୍ରାନ୍ସଫର ହେଲା ତାପରେ ମୋ ପାଖକୁ ଆସିଲା 18 ବିଲ୍ ହେଇଥିଲା। Yes. So what about any other council is ready for this one?
Item number 8.
8.
10 ready.
10 you are ready.
10.
10. Let us see the order of it. Here are the legal services.
If there is the item
Elaborate for the
10th,
which order dated here are the legal services.
Dijon deck, Dijon ajali.
May
1 and 2 is abated.
3 and 4 are alive.
Alive. Ladu Kishore and Judhisthira. That report dated 28/25.
This report from which we have passed on order 31/7/2024. 31, while placing the evidence of the witnesses, we found that Land Council for the Defense has confronted the previous statements of PW2 as well as PW19 during cross-examination, and some reply has been given by the said witnesses, so also by the investigating officer. When we tried to verify the case diary, we found that except one 161 CRPC statement, no other 161 CRPC statements are available. And the case diary is also not legible. Thus, the entire
I see.
court record is very much essential for disclosure of the case. So, you do number ଆଉ 19 number 161 ଅଛି ଦେଖିଦେଲେ ସେଟା ସ୍କାନିଂ ହେଇଯାଇଛି ତ ଦେଖିବୁ କେମିତି
ଆଜି ଆସିଛି।
2 number PW କୋଉ witness ଆମେ ଲେଖିଥିଲୁ ତା ଦେହରେ
PW2 and 19.
PW2 ର ନାଁ ହେଲା
19 and 161. ये दिखाରେ 160. PW2 ହେଲା କବିଚନ୍ଦ୍ର ପଣ୍ଡା।
ହଁ
ଆଉ 19 ହେଲା ଅଭିମନ୍ୟୁ ଡାକୁଆ। वन 161 ଟା visible ନଥିଲା ସେଇଥିରେ।
କୋଉଟା ଆଉ ପଢୁଥିଲୁ ଆମେ ଏଇ ଯୋଉଟା 317 ହଁ PW2 ଆଉ ଗୋଟେ ଅଛି PW19 PW2 ହେଲା କବିଚନ୍ଦ୍ର ପଣ୍ଡା ଦେଖିଲେ କବିଚନ୍ଦ୍ର ପଣ୍ଡାଙ୍କର
161 ଟା ଦେଖ କବିଚନ୍ଦ୍ର ପଣ୍ଡା
ଆଉ 19 ର ନାଁ ହଉଛି
ଡାକ୍ତର
ଅଭିମନ୍ୟୁ ଡାକୁଆ। ଏଇଟା ହଉଛି ସେ ଆଗରୁ ଥିଲା ଆମର ଲେଖିକି ମାତ୍ର ଗୋଟିଏ 161 ଥିଲା ଯଦି ସ୍କାନିଂ କରିବା କଥା ନା
जो गोटे थिला that was not legible and we asked for proof.
ଅଭିମନ୍ୟୁ ଡାକୁଆ ଆଉ ଗୋଟେ ହଉଛି କବି ଅଛି ହଁ କବିଚନ୍ଦ୍ର ପଣ୍ଡାଟା ଦେଖ
Exhibit code ହବ 161 ଟା ହେଇଥିବ exhibit ନୁହଁ 161 exhibit ହେଇଛି
କରିଦେଇଛନ୍ତି ଆଚ୍ଛା ହଉ
ଠିକ ଅଛି
ଆଉ କବିଚନ୍ଦ୍ର ଦେଖ କବିଚନ୍ଦ୍ର ପଣ୍ଡା କୁଆଡେ ଗୋଟେ ସ୍କାନିଂ କଣ ପାଇଁ କଲେନି ହଁ ଆମର couple lunch ସେଟା ହେଇଯାଇଥିଲା
ହେଇଥିବ
ଠିକ be ready huh we are coming up for lunch PW 16
ଓ ସେ କଣ କରିଛି not in separate sheet
अच्छा वो तो आधे लिख दीजिए
ହଁ
अच्छा
exam ଇଏ ହେଲା complainant nursing staff ତାପରେ witness is the non-party Chandra Panda enter ତାର ଯେ 169 ଟା 162
मेरा 162
2 ହେଇଗଲା
ସେ
161
କିନ୍ତୁ ତାକୁ ଦେଖିକି କହିଛି ସେ
ଇଏ ତାର ଥାର୍ଡ ପାର୍ଟି ରେ ସେ ତାର ଲେଖିଥିବ
ଏଟାକୁ ଜିଷ୍ଟ ଲେଖାଯାଏ ନା
ଏଟା
ତାକୁ
ତ ଜିଷ୍ଟ ଲେଖାଯାଏ କିନ୍ତୁ ସେ ତ
ପୁରା ଲେଖିଦେଇଛି
ଏଟା ପୁରା ଲେଖିଦେଇଛି ପୁରା examine him at this spot
ମାନେ ଏଠି ଇଥିଲି ଲେଖାଯାଇଥାନ୍ତା ସେପାରେଟ ସିଟ୍
separate sheet ଲେଖିକିରି ଆମର ଓଡ଼ିଆରେ ସେ ଦେଇଥାନ୍ତି
ଓଡ଼ିଆ ଲେଖାଯାଇଥାନ୍ତା
stated that Lingaraj Dakwa has got 2 sons load officer
ଏଇଟା ସିଡିଟା ହେଇଛି ସ୍କାନିଂ ହେଇଛି
ହେଇଛି
ସିଡି କଣ କୁହନ୍ତି এটা ଅଧେ ପଢି ହଉନି ନା ସ୍କାନିଂ
No, eyewitnesses. All are eyewitnesses.
No, but there was circumstantial evidence.
The father. The deceased.
Huh?
While the dead body was carried by the accused person to the cremation ground, the constable was obstructed. Suspicion.
Oh, Sita jo person.
Grammar of.
He was obstructed actually.
The dead body was
On the-
carrying by the all accused persons
Hmm.
to the cremation ground. The grammar of the PW 60.
He
PW
obstructed.
6 man.
6. They obstructed and asked them what is the cause of it. Then suspected something, intimated the IO.
I was.
Then IO came there and the dead body was came out from the that cremation.
Oh, 18,696, I was working as Grammarachi at a con Bodagoda PS.
Murder.
I am the informant of the Grammarachi is the informant
Informant.
of this case. The accused persons belong to Siddhapur. Accused Lodukisar Dakwan had married to one Lakshmi alias Namita village, Radhipalli, situated near Belaguntha. She married since 2 to 3 years back. Lakshmi used to stay at our village in the house of the. Oh, it's a bride day, bride death.
In cause of death,
It
con.
was,
Cause of doctor said no, that
ସେମାନେ କହିଲେ ଯେ ତାକୁ
Asphyxiation
dysentery ହେଇଥିଲା
to-
କିନ୍ତୁ asphyxia ହେଇଥିଲା strangulation.
due to strangulation.
Hmm. They took the plea of
Who are the appellants here?
Appellant is one is the father-in-law dead, two is the mother-in-law dead, three is the
Husband.
husband, four is the brother-in-law.
Brother-in-law.
তাহলে right now only brother-in-law has
Brother-in-law,
been.
husband,
Husband.
আচ্ছা
Para 12 PW3, observation of the learning trial court. His opinion that the cause of death due to strangulation resulting in asphyxia.
Hmm.
But they are giving a plea to others that the diarrhea and
Diarrhea ହେଇଥିଲା ବୋଲି ସେ ଗୋଟେ suggestion ଟା doctor କୁ ଦିଆ ହେଇନଥିଲା କି?
ହଁ,
But that is not the case. Defense ରେ ବୋଧେ doctor ଆଣିଛନ୍ତି ନା କଣ? ନାଇଁ doctor ଗୋଟେ suggestion ଦିଆ ହେଇଥିଲା।
କହିଲା ଯେ ସେ ତାଙ୍କୁ ଡକେଇଲେ ଯେ ଡାଇରିଆ ହେଇଛି ଟ୍ରିଟମେଣ୍ଟ କରିବ
କିନ୍ତୁ by then-
everybody was body was covered.
ହଁ ହଁ
He just declared the dead.
yeah right.
But by that time
He was not allowed to see the entire body. He saw took the pulse and found that she is dead.
So by that day, by the time the doctor PW8 was arrived on their call, they were died at that time. So entire things depend upon circumstances and evidence because they
PW5, his PW5.
Five.
Deposed that he is the medical officer posted at Siddhipur, the village of the accused persons, about 6 months back from the date of his deposition in court. At about 4 p.m., accused Lingaraj Dakwa called him informing that his daughter-in-law was suffering from dysentery, vomiting, and required treatment. He came to the house of the accused and found the entire body of the daughter-in-law of accused Lingaraj was covered, excepting her face. The wife of the accused Lingaraj was present near the patient. He examined her pulse and beating of heart and declared her dead. So they did not even allow the doctor to see the body.
Even if this is a daughter-in-law who was died for some other reason, anything would have been intimated to the family.
In-laws, to the.
So it created suspicion in the mind, their motive, and because
No, that is how the villagers only obstructed them.
obstruct.
So and so which villagers
PW
8 is there?
PW2.
2.
That is more important.
No. Acha. Oh, just a day before the
There-
death,
there
the
is a
parents
meeting.
were there.
Saptara Nari, they are called for a meeting. Saptara Nari meeting है ना समय how to
केबे से किए
अठारह छः छः
नहीं फादर इन लॉ कितने नंबर से
1990.
Yes, the पूर्व
After dinner, the villagers, some of the village entry were there. They just want to take but the deceased, but they
they did not allow.
So their statement that Lingaras also demanded some dowry in that.
That is a consistent one.
PW2 also stated. Parents of Lakshmi came to fall prior to 1 day of the death. Like the Lingaras never allowed Lakshmi to go with their parents. Lingaras gave a threat to the parents of Lakshmi. All and
Who is Lingara?
Yeah.
Father-in-law of the deceased.
Father in
That's that one also stated in his accused statement. ସାକ୍ଷୀ ମାନେ ମୋ ବିରୋଧୀ ଲୋକ ଲକ୍ଷ୍ମୀ ମରିଯିବା ପରେ ସେମାନେ ଥାନା ବାବୁ ଧରି ମିଛ କେସ୍ କରିଥିଲେ।
Who are now surviving 2 persons?
Husband and brother. Lord Kishore.
ଲଡୁ କିଶୋର ଡାକୁ ଯୁଧିଷ୍ଠିର ଡାକୁ
Kishore.
Now,
Lord Kishore Das.
Yudhishthir. That good.
Dakua. Husband.
husband.
How you
Yudhishthira Dakua, brother-in-law.
is 302 by 34 and 201 by 511.
The surviving appellants are for some. Page 28 is the only page mechanism to the sentence.
No, but if you come to the evidence of PW19, the father-in-law of these persons, that means the father of the deceased. Then let us say that homicidal, it's a case of homicidal death. How do you entangle this brother-in-law in that offense? Brother-in-law may be 201 by 511, but 302 by 34.
They are involved in demand of dowry.
No. Dowry ପାଇଁ ଇଏ ନାହିଁ ଅଛି ଆପଣଙ୍କର
Carrying the dead body, carrying the dead
ସେଇଟା
body.
ପୁରା ବୁଝି-
201
by
201 is there.
କାରଣ ଆପଣଙ୍କର ଦେଖିବେ ଯଦି ଏଭିଡେନ୍ସ ଅଫ ଦିସ୍ PW9 ସେ କହୁଛି ତା ଝିଅ ମଧ୍ୟ ଜଣେଇଲା ଯିଏ ଯେତେବେଳେ ଥିଲା ମାସେ ଖଣ୍ଡେ ସେତେବେଳେ ଲଡୁ ଆଉ ଲିଙ୍ଗରାଜ ତା ଘରକୁ ଆସିଥିଲେ
ତା ହଜବେଣ୍ଡ ଆଉ ତା
ଶ୍ୱଶୁର ସେମାନେ ଫୋର୍ସିବଲି ତାକୁ ନେଲେ ନେଇକିନି ଗଲେ ଏବଂ ଯୋଉ ଜଷ୍ଟ ତା ପୂର୍ବ ଦିନ ଯେତେବେଳେ ଆସିଛି ସେ ଲିଙ୍ଗରାଜ
ତାକୁ ଇନସିଷ୍ଟ କରିଛି ଡିମାଣ୍ଡ ଅଫ ଡାଉରୀ
ସେଦିନ so there is absolutely no allegation against
That's why the London trial court has not convicted Procedural for the present to that is sentence for.
ଯୁଧିଷ୍ଠିର କା କୋଉଥିରେ
Lord Kishore and Yudhishthira Dakua are sentenced on to legal change for 6 months for their conviction 201 5.
no
ନାଇଁ ଆଉ 302
302 କାଲ ଦେଇଛି
Husband is father-in-law and mother.
ଓହୋ ପ୍ୟାରେଣ୍ଟସ୍ ଇନ୍ ଲ ଆଚ୍ଛା
ଆଚ୍ଛା
ଏମାନେ 201 ରେ ଅଛନ୍ତି
That's
301 ପାଇଁ ସେ
ତାହେଲେ then it
page
is
27.
then it is
27
After sentence.
Lingaraj is sentenced to undergo imprisonment for life. Lingaraj is the father-in-law.
Father-in-law.
is no more
Is no more. He is sentenced to so and so.
The next page convict Sebat Dakua.
no both parents in law
ତାପରେ
to pay.
ये दी जन को केवल
201,511.
201/30.
अच्छा, for 2 years.
2 years.
अच्छा, अच्छा.
कितने रही थी लाभ
এটা ଦେଖିବା
नहीं 2 years could not
6 month এটা କେତେ ରେଟ କିଛି ଜାଣି
हाँ
ପିରିୟଡ଼ ଆଣ୍ଡ
so who has stated that they were carrying the body to the
PW6 ଏ ଯୋଉ ହଁ PW6 ଇନଫର୍ମାର
PW6
ये grammar.
ଗ୍ରାମର
informant let us see that ତାହେଲେ ଏଟା ବହୁତ limited ଜିନିଷ ଅଛି
ଲିମିଟ ଅଛି ଏ ଜାଗାଟା ଏମତି ଡ୍ର
ହଁ ଯୋଉ the main ଦିଟା ତ ମରି ଯାଇଛନ୍ତି ଆଉ you come to the PW6 madam please come to that
On 18/6/1996, I was working as Grammarokhi at Badagada PS. I know all these accused persons. I am the informant of this case. The accused persons belong to Sidhapur. Accused Latu Kishore Dakwa had married to one Lakshmi alias Namita of village Radhipalli, situated near Belogunta. She married since 2 to 3 years back. Lakshmi used to stay at our village in the accused persons. After her marriage, there was some quarrel between and ill feeling in the family between the deceased, with her parents-in-law and the sister of her husband. The parents of the deceased used to come to the house of the accused persons frequently in order to settle up the dispute or misunderstanding arose in the family. The parents of the deceased and their caste head man came from village Radhipalli to house of the accused persons and discussed some matters with them on 17/6/96 by staying from 11 to 4 p.m. The father and the village caste man requested the father-in-law Lingaraj Datta to allow the deceased to go with them for at least 2 months. But accused Lingaraj did not allow his daughter-in-law to go with her father and caste head man. On 18/6/96,
this is relevant the you 2015 with the
on 8/6/96, when I was passing through that village at about 9 a.m., I heard from certain females that the girl had been strangled to death on the previous night. I went towards the house of the accused persons and found that they were preparing to take dead body to the funeral ground for cremation. I found a heavy gathering when the dead body was brought from the house of the accused persons. Then I found accused Lingaraj Dakwa, Yudhishthir Dakwa, Ladu Kishore Dakwa.
this Ladu Kishore is now
Yudhishthir and Ladu.
Yudhishthir and
Ladu Kishore yes
Were carrying.
Were carrying the dead body of Lakshmi towards the ground. Lingaraj and Yudhishthir were ahead and Sepati and Ladu Kishore were behind while carrying the dead body of Lakshmi. I obstructed them claiming unnatural death of the lady and suspecting non-cooperation from the side of the villagers. I wanted to go to the police station to inform the police. The dead body was taken direct to the funeral ground and Ladu Kishore returned to take some pot for the purpose of a funeral function. I proceeded to the police station. I informed at the police station to the police in writing. Exhibit 3 is the FIR and Exhibit 3/1 is my signature. The FIR was lodged at 9 a.m. Police came to the spot and also came with them. The funeral pyre was
Already prepared
by the time of arrival of police. The dead body was brought out from the funeral pyre and the inquest over the dead body was held by the police. I found some marks of injuries on the neck of the deceased and on both the legs below. The knee joint, the dead body was also sent for postmortem examination. Lingaraj Dakwa has relatives
in that village.
read the cross examination.
Yes, my lord.
Page 68 सेटा रहउची 80 जो 80 out of 485580 पढ़ले पाइले
नहीं नहीं in the welcome
वाकम राशि तो अरे से 80 पेज टा बाहर करो लेजिबल होउनी
क्रॉस एग्जामिनेशन रा आसुनी
I have not visited the.
हां दैट इज क्लियर हां
I have not visited the village belonging to the father of the deceased. The domestic quarrel usually occurs in the house of everybody. I was not invited to interfere in such quarrel at any time. None called me for this purpose. I have heard about such quarrel. I have not gone to their house on 17/6/96 with the father of the deceased and their caste head man
when
when
the father of the
appeared in the house of the accused persons. I have heard from the neighbors like Anantaram Panda, Puri Panda, Bonamali Dakwa. I have not disclosed this before any of the villagers. I have not disclosed this to any of the villagers. It is not a fact that my house is at a separate locality. I belong to the same street of the accused persons. My house is at a distance of 30 houses from the house of the accused persons. I was my lord 16. 16.
कौन
I have not informed the police regarding the incident, which took place on 17/6/96. I cannot say the names from whom I heard about the death on 18/6/96. I have not gone to the house of the deceased when I heard about her death. I cannot say the names from whom I heard about the death of Lakshmi. I have not asked to the relatives of the accused persons as to why they did not cooperate the accused persons while taking the corpse to the funeral ground. It is not a fact that I have stated to the IO that accused Lingaraj Dakwa is a quarrelsome man having unsocial behavior and due to the same reasons. None is liking to him in any manner. No, he is fooling on well with the villagers. It is not a fact that I have stated to the IO that his own brothers and other relatives are also staying in that village and he has no talkative terms with them in any manner, and that Vishnupriya is also a notorious one. Vishnupriya had already married. I cannot say where Vishnupriya is, my lord, this is in Nalanda. It is not a fact that I have not stated to the IO that while passing through that village on 18/6/96, I heard from certain females that the daughter-in-law of Linga Dakwa was strangulated to death. It is a fact that I have not stated to the IO that while dead body was carried.
ଏଇଥିପାଇଁ ଆମେ ଡକେଇଥିଲୁ ଏଇ ଯୋଉ ଲାଇନଟା ହଉଛି
yes
ଇମ୍ପୋର୍ଟାଣ୍ଟ ଇଟ୍ ଇଜ ଏ ଫ୍ୟାକ୍ଟ ତମେ କି ଆଡମିଟ୍ କରୁଛି ବେଳେ ଲେଖା ହଉଛି I have not stated with the IO ଏଗୁଡାକ ଯୋଉଟାରେ ଆପଣଙ୍କର ଦି ଜଣଙ୍କର ଇମ୍ପ୍ଲିକେସନ ଆସୁଛି please read it out.
I heard from certain females that the daughter-in-law of Linga Dakwa was strangulated to death. It is a fact that I have not stated to the IO that while dead body was carried, I found that Lingaraj and Yudhishthir were ahead and Seboti and Lodukis were behind them while carrying the dead body. It is not a fact that I have not stated to the IO that I asked the accused Lingaraj as to why the other villagers were not cooperating with them in carrying the dead body. It is not a fact that I have not stated to the IO they prepared the funeral pyre and Lodu came to the village to take part. Accused Yudhishthir and are dealing with some Mali business.
Ajay, you come to the now, say पचराई जोटा confront ହେଇକିନି ବାହାରିଛି IO टू PW16 ର page को पळै आसंतु 91 paragraph number 7 तापर हम देखिबा से जो 161 रे कोन कुहा कि कोन न कोई.
Hello.
You got it that
paragraph 7
page होची 91 हां एटा IO रो एविडेंस टा
It is not a fact that PW6 Narasimha
Schedule 6 নয় তো এটা কি?
PW6 is the informant madam.
না এটা
না, না,
পড়িলে
এটা পড়লে Schedule 2 না?
PW6 পড়ুন।
6 পড়
6 পড়তলে।
গ্রামার কি করে এটা
Has not stated.
PW6. It is not a fact that PW6 Narasimha Sahu has not stated to me that accused Lingaraj Dakwa is a quarrelsome man and having unsocial behavior, and due to the same reasons none is liking to him in any manner, nor he is pulling on well with the villagers. He has not stated to me. Accused persons prepared the funeral pyre and the log book came to the village to take the pot. He has not stated to me that he observed the injuries on the neck and below both the knees of the deceased.
But what is the who held inquest over the dead body? PW16?
PW7.
7. What is the inquest report? মুক্তাপা উপরোক্ত গ্রাম্য মশাইন জমি সামনা রাস্তা করে আছে শ্রী জু কোনটা ମୁତାଫା ଉପରୋକ୍ତ ସ୍ଥାନରେ ଜୁଇ କାଠ ଉପରେ ପୂର୍ବକୁ ମୁଣ୍ଡ କରି ଚିତ୍ ହୋଇ ରହିଥାଇ ଆଖି ଦୁଇଟି ବନ୍ଦ ଥାଇ ହାତ ପାପୁଲି ଅଧା ମେଲା ଥାଇ ପାଟି ମୁଣ୍ଡ ପଶ୍ଚିମ ପଟକୁ ଶୁଆନ୍ତା ମୁତଫି ଲକ୍ଷ୍ମୀ ଡାକୁଆକୁ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ଗଡ଼ାଇ ଦେଖିବାରେ ମୁତଫିଙ୍କର ସଦ୍ୟ ରୂପେ ପୋଡ଼ା ହୋଇ ଯାଇଥିବାର ଦେଖାଗଲା। ଏହା ସହିତ ବାମ ବେକ ତଳପଟରେ 2 ଗୋଟି ସ୍ପଷ୍ଟ ଆଘାତ ପ୍ରାୟ 1 ଇଞ୍ଚ ବ୍ୟବଧାନରେ ଥାଇ ମୁତାଫାଙ୍କ ବେକରେ ସୁଆଂଶୁ କାନ ଠାରୁ ସୁଆଂଶୁ ଲିଗେଚର ମାର୍କ ଥାଇ ଗୋଡ଼ରେ ବନ୍ଧା ଗଣ୍ଠି ନିକଟରେ ସୁଆଂଶୁ ଚଉଡ଼ାର ଆବ୍ରେଜନ ଥାଇ ଉପରୋକ୍ତ ପ୍ରଥମ ଆଘାତ ଚିହ୍ନଟି ସୁଆଂଶୁ ପୋଡ଼ିବା ହୋଇଥାଏ। So that means there was an attempt also, some portion of the body has also burnt. अच्छा
obstruct କଲା ଥାନା କୁ ଗଲା
ତା ଭିତରେ ମାନେ ଫିନରାଲ ପ୍ୟାରେଡ୍ ନେଇକି
the villagers also did not cooperate to obstruct মানে obstruct them to not to unless the police would arrive at that particular time, that things would have seen.
So if that is the case, madam, if the evidence of this PW6 coupled with the inquest report and the postmortem report, because you have been found guilty only 2, that is Ladu Kishore and Yudhishthira. They have been found guilty under 201 by 511 and RI for 6 months, right? So जदि 6 नंबर साखी आउ के कहूना दी जो ये 6 नंबर साखी रो जदि एविडेंस टा एक्सेप्ट हुए जैसे आपण माने ताकू ये नबा पई प्रिपेयर करथले आगे रे ये चलथले पछे ये चलथले एवं तापर ताकू देखिकिनी ताकू मानिलेनी बड़ी सी आसिकिनी रिपोर्ट देला जाइकिनी पुलिस पहुंचला लोकू ऑलरेडी सब येकिनी माने पोड़ा आरंभ पोड़ा दाग गुड़ाक अच्छी इनक्वेस्ट रिपोर्ट भी देउछि तेणु दैट इज कॉजिंग डिसअपियरेंस ऑफ एविडेंस अटेम्प्टिंग इट इज नॉट fully 511 is there
fully accomplish नथिला
how do you say and it's not a natural death so some offense has been committed and you are aware of it in spite of that when the co-villagers did not cooperate with you you foretook the body and then in the cremation ground we find that he was on the pyre and there was almost some frame was there for which he has sustained some burn injury. So 201 ro ingredients which is the study karajivo that you come to 201. What is how do you get over it? Just read it and place your case in that.
causing disappearance of the evidence of offense or giving false information to screen of offender. Whoever knowing or having reason to believe that an offense has been committed.
Pause for a moment. You are the family members, in-laws family members,
Yes, ma'am.
or these two appellants are the husband and brother-in-law, there is no dispute. The deceased was staying in your company. She has died a homicidal death. Death was on account of strangulation. So that is why, so you have knowledge that the offense has been committed. Otherwise, you could have said that we are, so it is not like that. जो explanation टा अपन दौचंती झाड़ा बांती that cannot be accepted because of the post-mortem report. So the court can see that you had knowledge about the commission of the crime. Then read it out.
Whoever knowing or having reason to believe that an offense has been committed causes any evidence of the commission of that offense to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offense which he knows or believes to be.
This is not a case of giving any false information. Of course, in the at a later stage, you have stated that jo jhada banti, but cause the evidence of the commission of offense to disappear with the intention of screening the offender from. So you yourself knew that it is not a natural death. It is a case of homicidal death. In spite of that, you carried the dead body to the cremation ground, prepared for cremation, and the body was on the pyre. The burnt, some portion of the body had also caught fire. That is the inquest report. And so now, how do you say that there is an attempt 511 is into causing disappearance? How it you will overcome it?
My lord, PW2 and PW6. PW6 informant is the brother-in-law of PW2. PW6 was Gramorakhi in that village.
And PW2?
PW2 is
Front door neighbor.
front door neighbor. There is a rivalry between the villagers and the deceased family.
Where is that? Where is that? In PW2, have you brought anything? Because in PW6, we have seen nothing has been brought. PW2?
PW2, no.
He was not pulling on well with the villagers in general. It is there.
Because one of the reasons may be there, PW6 has stated.
If you come to the second page of PW2's evidence, please come to the second page. That means page number 55.
Right.
He has stated that, say, noise for sunna, fifth line from the top. All the accused persons were found carrying the dead body at 9 AM. I entertained a doubt and contacted Gramorakhi. Gramorakhi means PW6.
PW6.
To obstruct the accused persons from carrying the dead body to the funeral ground. So I also advised him to bring the matter to the notice of the police. Nursing Sahoo is PW6. Obstructed the dead body on the way, but the accused persons took the corpse to the funeral ground. Then police arrived at the funeral ground with the Gramorakhi. They prevented the accused from burning the dead body. The dead body of Lakshmi was brought out from the funeral pyre and brought under a tree. There are marks of injury on the so and both the thighs. Then inquest report was prepared. So this evidence corroborates the evidence of the Gramorakhi PW6. So if these two evidence are taken into account, coupled with inquest report, the statement of the investigating officer who arrived in the in that burial ground, then is PW16. When he has come to the burial ground, he has also seized some half burnt woods, etc. The seizure list is there. PM किए କରିଛନ୍ତି?
PW 3 and 4.
3 and 4.
Blisters were present
Hmm.
various sizes over the body. ये जो जिनिस
Blister
गुड़ाक
ହେଇଥିଲା।
गुड़ाक far ये
ପୋଡିକିରି
Burn
blister
injury.
ହେଇଥିଲା।
so we are just taking into all those things which are connected for this 201. We are not like fracture of so and so. It's a case of homicidal death because he has stated that it is a case of strangulation and जो पायर ऊपर रखा ହେଇଥିଲା तार corresponding येटा मध्य आसुची। किसी बाहर नहीं अपन को क्रॉस एग्जामिनेशन ने
all the sign of transmission is the thermal present.
No finger marks were on the neck.
No, we are not on that.
ये 302 दरकार अपन को दीटा दरकार ये हिची गोटे सॉरी केवल 201/511 हिची अपन सेगुडा को
Here we need only to see whether the death was unnatural or not. So once it is found that the death is unnatural, there is chance of this evidence screening out because you were trying to disappear the evidence.
ये दी जन को निया इतला कस्टडी को 24 छह अलग रे फाइनल फॉर्म देखुची when they were granted bail because when the case came to the session judge court sethi order sheet देखुची all the accused persons are present, they were on bail. All the accused persons have been really 21/3/17 order कोची से माने bail ले थिले बेली
26/9/2000 से मैंने बेल ले अछन लड्डू की छटा को अंड
केबे
26/9/2000
ना 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 ता आगे अच्छा
we are in
lower court
right now.
lower court से मैंने already थिले
कारण एठी ये जो येटा पड़ा गला मजिस्ट्रेट रो ऑर्डर शीट देखले जाना पड़ियो
it is
ऑर्डर शीट हां एठी आसला हमर ला एटा आसी जाइछंदी 24/6 रे भितरु जाइछंती प्रोड्यूस के बेजन 25/6 प्रोड्यूस हेजन 25/6 रे यू in court these two pilot age order sheet तळे जो मजिस्ट्रेट order सेटा तो होची सेशंस कोर्ट आउट तळे अछि सेटा देखुची accused person so and so ता धीरे जे दी जनकर ना होइछि युधिष्ठिर डाकुआ नंबरटे आ गोटे लडू किशोर डाकुआ 4 नंबर टा होची लडू किशोर 5 नंबर टा युधिष्ठिर 25/96 रे प्रोड्यूस
all are of village amukam
प्रोड्यूस तापरे गला
to expert party
हां तापरे बेल
ता माने 22/6 नंबर
उन्नीस 9/2006 उन्नीस लिखा है इन दी रिजल्ट द मिस केस इज अलाउड पेज नंबर होची 337 हां इन द रिजल्ट द मिस केस इज अलाउड extract of sona extract Ladu Kishore and Yudhishthira are released on bail 10,000 sponsor so 19/9 रे आपण जदी बेल गले तामने आपण रहिसंती about 3 months obviously trial court रे आपण भितरु जाई नथिबे कारण conviction जेहेतु 6 मास हेतियो बोधे ताऊ छडा ही हेतियो
2 वर्ष अछि
नहीं नहीं 6 मास ना only 6 months
6 months.
Convictions.
They have
only 6
sentenced to
months
6
only
conviction date रे लिखाई छी ये 6/9/2000 तो conviction है जी हाँ देखो तो डेट
6/9/2000
हाँ 6/9/2000 order sheet पे कुछ 6/9/2000 conviction है accused so and so guilty under section so and so they are not found not guilty under 302 so and so then memo filed
2 years
to
it
not huh
2 years he is also sentenced to undergo Rakutre
no
for 6 months
This buddhi at
नहीं एटा हला convict Lingaraj Dakwa is sentenced to undergo rigorous imprisonment for life and to pay fine of rupees 5,000 in default to undergo rigorous imprisonment for 6 months and for his conviction under 302/34 he is sentenced to undergo rigorous imprisonment for 2 years and to pay fine of rupees
Lingaraj को ही
in default to undergo for
498
498A. He is also sentenced to undergo rigorous imprisonment for 2 years for his conviction 201.
ताकि कर दी
5
3
lakh.
वर्षों
And also sentenced to undergo rigorous imprisonment for 6 months and to pay fine of rupees the default to undergo imprisonment
for
for the
DP Act.
for 4DP Act. Convict Sevati Dakwa is sentenced to undergo rigorous for 5,000 in default. She is also sentenced to undergo for 2 years. Gala. Convict Lodukisar and Yudhishthira are sentenced to undergo rigorous imprisonment for 6 months
6 months
each for their conviction. 6 months. And 6 months or 3 months. Actually.
and so and so the district are put on bail and the ground for and
Commitment जो है commitment परे आगले की किछि दिन रहले की
नहीं commitment तो bail लेतिले से
बेले गले
ଆଉ ସେ ଏଠି ମଧ୍ୟ 6/9/2000 ହିଁ ତାଙ୍କୁ bail ଦେଇ ଦେଇଛି
अच्छा
टाइम दे
ये तो less than ये था 389 रे सन पाई छन
टाइम ଦେଇଛନ୍ତି ତାଙ୍କୁ ମାସେ ଯାଇ bail ଆଣି
389 2 ରେ से पळे
so ତିନି ମାସ ପାଖାପାଖି ଆଉ ତ ଏତେ ବର୍ଷ ହେଲାଣି ଆଉ କଣ ଯିବେ ଭିତରକୁ 96 ମସିହାରେ ହେଲେ ଆମେ ପ୍ରାୟ 30 ବର୍ଷ ହେଇଗଲାଣି ପାଖାପାଖି ଆଉ କଣ କହିବେ nothing is there two evidence is sufficient 2 and 6 sorry 2 and 6 not 3 and
2 and 6
2 and 6
cross-examination. We do need to cross-examination about the
on that no
about this aspect
ଏଇ ଯୋଉ ଜିନିଷ aspect ରେ କୁହନ୍ତୁ ଅନ୍ୟ ବହୁତ ଜିନିଷ ବାହାର ଥାଉ
अन्य जिनस तो ଆମେ ନା ହଉ we are not on that
accused statement of Lingaraj Dakwa.
ଲିଙ୍ଗରାଜ କୁ କାଇଁ ପଢୁଛନ୍ତି ଲିଙ୍ଗରାଜ is not before us
ଲଡୁ କିଶୋର ବି କହିଛନ୍ତି ଯେ
ଲର୍ଡ କିଶୋର କଣ କହିଛନ୍ତି
ଲୋକମାନଙ୍କ ବିରୋଧରେ ଥିବା
ହଁ
ତାଙ୍କୁ
କହିଛନ୍ତି
କହିଛନ୍ତି
ଯେ, but how can you when you are unable to demolish the evidence of these two witnesses 2 and 6
and the doctor
and the inquest report
see it was already in the funeral pyre and the evidence from the doctor is there that half burnt is already there half burnt wood is there evidence to the effect that see they were taking the dead body to that place and it was brought out from the funeral pyre it is also there up to that extent what is there how you have demolished
normally in village if somebody is died in a house at least to intimate the neighbors relatives to come these things are there alone they are taking
no, because they did not get support from the villagers they themselves were taking.
ଚାରି ଜଣ ନିକଲେ
ନେଇକି ଯାବେ।
ନେଇକିନି ଇଏ ଆଗରେ 2 ଜଣ ପଛରେ 2 ଜଣ ସେ ସେଇ ପୋଜିସନରେ ଦେଖିକି ଗଲା ମନା ହେଲା ମାନିଲେନି ଥାନାରେ ଯାଇ କହିକିନା ଆସିଲା ବେଳକୁ ଅଲରେଡି ମାନେ ଷ୍ଟାର୍ଟ ହେଇଗଲାଣି ବୋଧେ ଆଉ ଯଦି ଅଧଘଣ୍ଟେ ଘଣ୍ଟେ ହେଇଯାଇଥାନ୍ତା ପଡି ଯାଇଥାନ୍ତେ ତ immediately he First information report indicates that the place of occurrence is 7 kilometers away from police station. 7 ये जाइथिबो से 7 आस्तिबो 14 किलोमीटर आइला बेलको ऑलरेडी अरेंज करी ताकू पोड़ा पोड़ी स्टार्ट कर देले देखिरो प्रोफेसर এটা কোনটি
Gary,
আমি তো এটা আউট অফ প্রসিডিউর আমি ইয়ে করব এটা আমি এটা ট্রাই করি আচ্ছা এইটা মোবাইল দি পেপার বুক অফ দিস কেস criminal appeal has been filed by Lingaras Dakwa, his wife Seboti Dakwa, and their two sons, Loru Kishore Dakwa and Yudhishthir Dakwa. Since Lingaras Dakwa and Seboti Dakwa are dead, as per order dated 13/8/2024, the court has directed the appeal to be abated in respect of those two appellants. Now the appeal survives only for Lodukishore Dakwa, the husband of
this is
the
Lakshmi.
deceased.
Lakshmi.
Which is Lakshmi.
Namita alias Lakshmi. Namita alias Lakshmi.
Lamita alias Lakshmi Dakwa and Yudhishthir Dakwa, the husband's elder brother, bracket lingam, brother-in-law of the deceased. The four appellants, along with one Vishnupriya Dakwa, the sister-in-law of the deceased, faced trial in the court of London Additional Session Judge Bhajnagar, Aska, in Sessions case number 5 of 1999 for offences punishable under section 302/34, 498A/34, 201/34, and 304B/34, and section 54 of Dowry Provision Act, and section 4 of Dowry Provision Act. The London Trial Court had impugned judgment and order dated 6/9/2000, acquitted Vishnupriya Dakwa of all the charges. The Lingaras Dakwa, bracket dead, and Seboti Dakwa, bracket dead, were found guilty under section
30234.
The body found guilty. अच्छा the nine the appellant linger as Dakua
And so the Dakua.
The appellant linger as Dakua was found guilty under section 302/34, 498/34, no, 498A, 201/511 of IPC and section 4
of
DPR. And however, he was not found guilty under section 304B of the Indian Penal Code. So far as appellant Dakua is concerned, she was found guilty under section 302/34, 201/511 of the Indian Penal Code, but she was not found guilty under section 304B/34, 498A IPC, and also under section 4 of the Dowry Prohibition Act. The appellants Lodu Kishore Dakua and Yudhishthira Dakua were acquitted of the charges under section 302/34, 304B/34, 498A/34 IPC, so also under section 4 of the Dowry Prohibition Act. However, they were found guilty under section 201/511 of the Indian Penal Code and sentenced to undergo rigorous imprisonment for 6 months each. The prosecution case, as per the first information report, lost by PW6 S.K.Sahoo before the officer in charge of Bodagoda Police Station on 18/6/1996 in short is that on that day, early morning at about 7 a.m., he had been to village Godar with one Kala Gouda. And at about 9 a.m., he returned to his village and came to know that the deceased, who had married to the appellant Lodu Kishore Dakua about 1.5 years prior to the incident, had died. And the in-laws, family members of the deceased had not intimated any of the family members of the deceased, and spreading a propaganda that the deceased died out of dysentery. And preparing for cremation of the dead body. On hearing such news from others, the informant became suspicious and stopped. Previously, the Deceased was subjected to physical and mental torture by her in-laws family members. And over this issue, there was settlement between the parties, and in presence of the villagers, the in-laws family members were asked not to torture the deceased. One day prior to the date of occurrence, the parents of the deceased, along with the villagers, had also tried for amicable settlement of the dispute between the parties, but since it could not be made possible, they had left for their house. It is further stated in the FIR that over this issue, while both these appellants, that is Lodukishore Dakua and Yudhishthira Dakua, were absent in the house, the parents-in-laws and the sister-in-law of the deceased assaulted her and strangulated her to death by means of a rope and stop. Over this suspicion, the the informant also tried to restrain the in-laws family members of the deceased not to take her to the burial ground for cremation, but they didn't listen to him, and accordingly PW6 came to the police station to lodge the first information report. Stop Sapwara. On the basis of such first information report, Borgod PS case number 45 dated 18/6/1996 was registered under section 302, 201, 498A by 34 of the Indian Penal Code. Stop. PW16 the IIC of Borgod Police Station, after registration of the case, visited the spot, prepared the spot map exhibit 9, examined the witnesses, seized the half-burnt woods, etc. From the cremation ground, by seizure list exhibit 6. He also seized the plastic thread on being produced by appellant Lingaraj Dakua bracketed dead from his house under seizure list exhibit 8, held inquest over the dead body of the deceased and prepared the inquest report exhibit 1 and sent the dead body of the deceased to Bhanjanagar SD Hospital for postmortem through constables. He also seized some dowry articles from the house of the appellants under seizure list exhibit 7 and left the same in the Jima of Abhimanyu Dakwa. Abhimanyu Dakwa kete number saki? Acha PW 19 under Jima Nama exhibit 12. He arrested the accused persons on 24/6/1996 and forwarded them to court on 25/6/1996. On 29/7/1996, he made a query to the medical officer regarding the cause of death of the deceased, and on his transfer, he handed over the charge of investigation to the Inspector D.P. Patro, bracket PW 13. The Circuit Inspector of Police. As for the direction of the Ganjam, who on completion of investigation,
SP Ganjam, direction.
SP Ganjam, who on completion of investigation submitted charge sheet against the accused persons under section 498A 302 304B 201 Y34 of the Indian Penal Code and section 4 of Dowry Prohibition Act. The case was committed to the Court of Session after complying the due procedure, where the learned trial court framed the charges as aforesaid. Since the accused persons pleaded not guilty and claimed to be trial, the sessions trial procedure was resorted to prove their guilt. Stop. The defense plea of the appellants, Loru Kishore Dakua, as well as Judicial Dakua, are that after hearing the death of the deceased, they came to their house and found the deceased dead, and they have been falsely entangled in the case. Stop. In order to prove its case, the prosecution examined 19 witnesses. The prosecution also exhibited 12 documents, and prosecution proved 4 material objects. Stop. The London trial court, after assessing the oral as well as documentary evidence on record, on the basis of the evidence of the doctor and the post-mortem report, came to hold that it's a homicidal, the deceased made homicidal death. The London trial court found the plea taken by the present appellants regarding their absence at the time of occurrence
and came to that the accused Lingaraj, being the father-in-law of the deceased Lakshmi, subjected her to cruelty, and therefore the charge under section 498A is proved against him. It was further held that the accused persons Lingaraj and Sevati murdered the deceased and made an effort to color her death due to natural causes like loose motion and vomiting, and attempt to cause the evidence of the commission of murder to disappear by taking the dead body of the deceased to cremation ground, putting it on the fire and lighting the fire. And the dead body could be retrieved by the intervention of the police. Lodukishore Dakwa and Yudhishthira Dakwa are concerned, on their arrival in the morning, they must have seen the injuries on the neck of the deceased and must not have seen anything indicating that the deceased was suffering from loose motion and vomiting prior to her death. Knowing and having reason to believe that the deceased was murdered, they assisted their parents to destroy the dead body of the deceased. Accordingly, the London Trial Court held that the charge under section 201, read with section 511 of the IPC, has been proved against the appellants Lodukishore and Yudhishthira, so also accused appellant Lingaraj Dakwa and Sevati Dakwa. The London Trial Court further held that the appellant Lingaraj Dakwa bracketed dead, being the father-in-law of the deceased, demanded color TV ornaments fan from the parents of the deceased and subjected her to cruelty in order to put pressure to get those articles, and accordingly found that charge under section 4 of the Dowry Prohibition Act is brought home against him. Stop. Since the two appellants who have been found guilty under offense under section 302(y)(34) of the Indian Penal Code are now dead, and the appeal has abated against them, we are to confine this judgment, whether the materials available on record are sufficient to hold these two appellants, namely Lodukishore Dakwa and Yudhishthira Dakwa, guilty under section 2, read with section 511 of the Indian Penal Code. The evidence of two witnesses, that is PW2 and PW6, apart from the evidence of the doctor, Dr. Takye postmortem करते
3 and 4.
PW3 and 4 who conducted postmortem examination, as well as the inquest report, bracket exhibit 1, are very material for this purpose. PW2 has stated
that date of occurrence at about 9 a.m., he found all the accused persons carrying the dead body. He entertained a doubt and contacted Gramaraki, bracket PW6, to obstruct the accused persons for carrying the dead body to the funeral ground. He further stated to have advised the accused, PW6, to bring the matter to the notice of the police. Stop. He stated that S.K.Sahoo PW6, PW6 obstructed the dead body on the way, but the accused persons took the corpse to the funeral ground. Police arrived in the funeral ground with Gramaraki. They prevented the accused persons from burning the dead body, and the dead body of the deceased was brought out from the funeral pyre and brought under a tree. And marks of injuries on the neck of the deceased and on the thighs of the deceased were noticed, and accordingly the inquest report was prepared. PW2 signed the inquest report. Stop. In the cross-examination, he has stated to have seen one female pot maker going to the house of Lingaras Dakua in the morning. But he had not seen anybody else going to the house of the accused persons in the morning. It has been confronted to PW2 and proved through the investigating officer, bracket A, your confrontation কি প্রমাণ করেছি?
ये 16 12 9 করতে যাইছি
PW6 or
it is not affected PW6 not single subject. Two of which
আচ্ছা,
let's say it is not a fact. It is a fact that I have not stated.
it is a fact that I have not stated the frequent calls numbers that I have not stated. Why don't it's a fact that I have not stated? There was influence. Wait one, I have not started responsibility. The fact that I have not. Acha. In this witness has admitted in the cross examination not to have stated before the investigating officer that he instructed PW6, the Gramaraki, to obstruct the carrying of the dead body by the accused persons. He further admits not to have stated to the IO that he instructed PW6 to report the matter at the police station. He has denied the suggestion given by the defense that since he was not pulling on well with the accused persons, he was deposing falsely. The evidence of this PW2 that he found that the accused persons were carrying the dead body at 9 p.m. for which he entertained doubt and has not been second in the cross-examination. So far as PW6, the grammar is concerned, he has stated that on 18/6/1996, while he was passing through the village of the appellants at 9 a.m., he heard that from some females that a girl had been strangulated to death on the previous night. He went towards the house of appellants and found that they were preparing to take the dead body to the funeral ground for cremation. And he found a heavy gathering when the dead body was brought from the house of the accused persons. And he specifically stated that accused Lingaraj Dakwa, Yudhishthira Dakwa, Lodukishore Dakwa, and Seboti Dakwa were carrying the dead body towards funeral ground. Lingaraj and Yudhishthira were ahead, and Seboti and Lodukishore were behind while carrying the dead body of Lakshmi. He has further stated that he obstructed the accused persons, claiming it the unnatural death of the lady and suspecting non-cooperation from the side of the co-villagers. He went. He wanted to go to the police station to inform the police. He further stated that the dead body was taken direct to the funeral ground, and he proceeded to the police station and informed the matter in writing. And the police came to the spot, and he also came with the police. The funeral pyre was already prepared by the time of arrival of police. The dead body was brought out from the funeral pyre, and the inquest over the dead body was conducted by the police, and he found some marks of injuries on the neck of the deceased and on both the legs below the knee joint. Stop. In the cross-examination, In the cross-examination, he has admitted that he has not stated to the IO that while the dead body was carried, he found Lingaraj and Yudhishthira were ahead and Seboti and Laurukisho were behind them while carrying the dead body. It has been confronted to PW6 and proved through the IO bracketary PW16 that he has not stated in a statement that the accused persons prepared the funeral pyre and that he observed injuries on the neck and below both the knees of the deceased. Stop. The evidence of the doctor who conducted post-mortem examination at this stage is very relevant. PW3 and PW4 both conducted post-mortem examination, and PW3 has stated that on 19/6/1996, he was the pediatric specialist, SD Hospital, Bhanjanagar, and he conducted the post-mortem examination over the dead body of the deceased and noted following injuries, quote from page number 59 to 60 parjanta, including the cause of death, so and so. Nothing has been paragraph here. Nothing has been elicited in the cross-examination to challenge the conclusion arrived by the doctor that it was a case of asphyxia. It was due to asphyxia on account of strangulation. The inquest report clearly, bracket exhibit 1, clearly indicates that there was some burn injuries sustained by the deceased when it was recovered from the fire. In the PM report also, the doctor has noticed blisters of various sizes were present all over the body. The IO bracket PW16 has stated that he seized some wood, half-burnt woods, etc. One cooler and other materials used under seizure list exhibit 6. Stop. The evidence of the aforesaid witnesses clearly indicates that the deceased had met a homicidal death on account of strangulation, and the body of the deceased was carried to the funeral ground in spite of objection of PW6, and it was placed on the fire, and the PW6 along with the police came and the body was recovered from the fire, for which there were burn injuries and blisters noticed on the body. Stop. The section 201 of the Indian Penal Code deals with causing disappearance of inter alia deals with causing disappearance of evidence of the offense. And it states that whoever knowing or having reason to believe that an offense has been committed, causes any evidence of the commission of that offense to disappear, can be said to have committed the offense under section 201 of the Indian Penal Code. Thus, the ingredients of section 201 of the Indian Penal Code are as follows. 1, an offense has been committed. 2, that the accused knew or had reason to believe the commission of such offense. Number 3, that with such knowledge or belief, he caused any evidence of the commission of that offense to disappear. Mere suspicion is not sufficient. There must be available on record cogent evidence that the accused had caused evidence to disappear in order to screen himself or another from the offense. The act must have been done with the intention of screening the offender from legal punishment. In the case in hand, there are ample material on record that the present two appellants were aware that an offense has been committed in view of the nature of injuries sustained by the deceased, which they must have marked at the time of carrying the dead body and also at the time of putting the body in piles for cremation. Stop. The act committed by these two accused persons, along with the other two accused persons who are now dead, in carrying the dead body to the funeral ground without even intimating the family members of the deceased and the police. Also another factor which goes against them. It further appears from the evidence that in spite of the restraint being made by PW6, they didn't listen to him, but took the dead body to the cremation ground and made every endeavor to put it on the fire solely for the purpose of causing disappearance of the evidence. If the police would have reached at a belated stage, the evidence might have been totally destroyed. But the police reached in time with PW6, and that is how the body was brought from the fire, and inquest was held over the dead body, and burn injuries were noticed apart from the injuries on the neck and other parts of the body, and it was also sent for post-mortem examination, and it was confirmed that it was a case of homicidal death. Therefore, we are satisfied that the accused persons, the appellants, had knowledge that an offense has been committed, and with such knowledge, they attempted to cause the evidence of commission of the offense to disappear. And therefore, the London Trial Court has rightly found the appellant guilty under section 201/511 of the Indian Penal Code. Stop. It appears that the appellants were taken into judicial custody in connection with this case on 25/6/1996, and they were on bail on 19/9/1996. However, after their conviction, they were released on bail under section 389 of the CRPC by the London Trial Court, so also by this court, and thereafter they were not taken into judicial custody in connection with the case. Thus, the two appellants have remained in custody for about 3 months. Stop. The occurrence in question took place in the year 1996, and almost 30 years back, and the two appellants are now aged about more than 60 years, and at this stage, in view of the passage of time, the sentence under section so and so is reduced to period of under term. Accordingly, the criminal appeal stands dismissed subject to modification of the sentence. So, note of appreciation in the running counsel. Madam, what is your name? Name of the counsel, Mr. Mahathir. So,